Come bella c'è la luna, brilla stretta, stretta come tutto belle pasteggiano sotto il cielo di Roma. Down each avenue or via street or strada, you can see them disappear two by two on an evening in Roma. Do they take him for espresso? Yeah, I guess so. On each lover's arm a girl I wish I knew on an evening in Roma. There's grinning and mandolining in sunny Italy. The beginning has just begun when the sun goes down. So please meet me in the plaza near your casa. I am only one and that is one of the few on an evening in Roma. Don't know what the country's coming to, but in Rome there was a rendezvous. Will you on an evening in Rome? Come bella c'è la luna, brilla strette, strette come tutto belle pasteggiano sotto il cielo di Roma. Don't know what the country's coming to, but in Rome there was a rendezvous. Will you on an evening in Roma sotto il cielo di Roma? On an evening in Roma.
Baby, let's see how fast this all black Silverado goes. And how many miles is it gonna take to get away from you? You're breaking on the cabo's heart. You got me drinking at a downtown bar. I'm overthinking, getting too damn drunk, and that's what I get for falling too in love. Remember that back road, baby. Remember them stars in the sky. Remember that tailgate we were sitting on when you looked me in the eye. I remember those backwoods, baby. We would roll them up and get high. Said we'd stay here and plant roots till you and I die. Guess I'm just learning how to let it go. Guess I'm just learning how to let it alone. It's hard for me to take it slow, slow, slow. So, baby, let's see how fast this all black Silverado goes. And how many miles is it gonna take to get away from you? You're breaking on the cabo's heart. You got me drinking at a downtown bar. I'm overthinking, getting too damn drunk, and that's what I get for falling too in love. I don't think you care. I'm putting my heart on ice and cold beer. Baby girl, it's no fair. Baby girl, it's no fair. It's all your fault and you know it. This shit is driving me insane. I saw this truck parked in your driveway at your place. Now I'm packing all my things trying to get away. Baby, let's see how fast this all black Silverado goes. And how many miles is it gonna take to get away from you? You're breaking on the cabo's heart. You got me drinking at a downtown bar. I'm overthinking, getting too damn drunk, and that's what I get for falling too in love.
Hello! Good morning. I'm Mattel. How are you all doing? Wait a minute. Okay, that should be working. How are you doing? Good to see you all. I told you I would be back once we had the hearing. We have the hearing. We can talk about it now. And then I did some research about things that occurred at yesterday's Colin Albert and Karen Reed motion to compel hearing. It turns out this is very fascinating. Thank you, Margie. The defense team has confirmed that it will be Waters deposing Colin, not Alan Jackson. Alan Jackson, of course, will be in town, I believe. We don't know if it's going to be this week or if it's going to be July 14th to depose Michael Proctor. Now, frankly, I would have sent Alan Jackson to the Colin Albert depot. That's just me. I think Alan knows that part of the case the best, but, you know, Alan's very smart. But Michael Proctor is certainly being deposed by Alan Jackson. That I know for a fact. That was announced in open court. But either way, we have a lot to talk about. My name's Grant Smith Ellis. Good morning. So good to see you all. I told you we would watch yesterday's hearing as soon as I got it. I didn't get it till late at night, and then I was sleeping. So we'll watch it now. And Boozy Beauty did a really good job, as you noticed during yesterday's stream, reporting on what happened. However, I want to watch the hearing with you. I want to talk about it. And then I want to talk about like a fundamental thing that Colin Albert's lawyer, remember, this is Colin Albert's lawyer arguing that he should not have to be deposed because Karen Reed's lawyer sent him a subpoena and then he joined the army after the subpoena was issued. We're going to hear him, the lawyer for Colin Albert, say a few weird things. And then I did some research into the Code of Federal Regulations, as one is wont to do. And as far as I could tell, this has never happened before. I can't find a single case where I found cases where someone was in the army and they got subpoenaed, or someone was on leave from the army and they got subpoenaed. But I've never found a case where someone got subpoenaed and then joined the army. I've never found such a case. All right, so as a result, here's what we're going to do. I'm going to show you the hearing. Then I'm going to show you the nature of the section of the Code of Federal Regulations that I believe pertains to what happens when you want to serve a civil deposition subpoena on a person in the Army. Now, it's complicated. You're going to find out that it's complicated, but you're also going to find out that some of the representations made to the court by Colin Albert's lawyer are either not he didn't read the relevant sections of the CFR, or he just is trying to cover for Colin Albert and just pray Judge Gildea doesn't want to deal with the nuances. Now, you're also going to find out there are actually some burdens imposed on Karen and her lawyers under the relevant section of the Code of Federal Regulations to make this happen. But before we even get there, we got to watch the damn hearing. So, my name's Grant Smith Ellis. I told you as soon as I got this hearing from yesterday, I would watch it with you. We're going to do that now. Thank you to Canton Community TV for the pool feed. Judge Gildea does not allow live streams, so the reason we have to do it this way is you can only upload it with a delay. And the hearing was 45 minutes, and Canton Community TV helpfully cuts out the sidebars, so, because it's just static noise. So it takes 6 hours to process and upload, and they got this up real quick. So we're going to watch it, I'm going to talk about it, and then if I can get the new Turtle Boy filings, I will talk about those. Then I'm going to talk about the relevant section of the Code of Federal Regulations in the context of the Colin Albert subpoena, and it turns out he cannot evade this subpoena. Being in the Army does not allow you to evade it, but there's a very specific process that Karen has to follow, I believe. I'm not a lawyer, this is not legal advice, but I did go to law school. So anyway, let's talk about it.
3CV00692, Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III,
yes, Petty LaBelle
versus CNC Hospitality, LLC, doing business as C&F McCarthy's et al. Counsel, if you could please state your name for the record because I'm with plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Aaron Rosenberg on behalf of defendant Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Sarah Shipley on behalf of the defendant Karen Reed.
And good afternoon, Your Honor. Chris Maddy on behalf of non-party witness Colin Albert. I'd like to thank the court for its consideration of allowing me to participate today, even though I'm pro-hocked in on the defamation case and not on this one.
No problems. Without objection, correct?
Correct.
Okay. So, does the email you sent this morning, Attorney Rosenberg, to the clerk reflect the present status of the parties? Yes, Your Honor.
Okay.
And with respect to, you basically have two categories that are the subject of discussion, correct? The communications with the deponent's parents would be one category, and then the other one would be communications with others.
Yeah, that's not exactly how we'd been discussing it last, but I see how you're saying that. Yeah.
Okay, and then in the email to Attorney Maddie today, or I don't know when it was, I guess it was on Friday.
Yeah, Friday, I think.
You reference a date range of January 28th, 2022 through December 31st, 2023. What category does that relate to?
So it would relate to both in part. So as you know, we originally had.
Just tell me.
Well, it would relate to.
We're back. Hello. It was raining here this morning. I have really good internet, but the rain makes it all made. It's very fast speed satellite internet. Hello, we're back. Let's continue with the hearing.
Okay. And then for the parents, there are two separate proposals we made. One was
A and B in the email.
Correct. So it would apply to B in that email as well. So it would apply to everyone.
Okay, and then are the communications that you talked about, the period of January 28th, 2022 through April 30th, 2022, which were a subset of the parent ones?
Correct.
Are those limited by the which relate to language?
No, and there was a reason for that. So obviously one of the disputed issues, as you can see in the papers, is Mr. Albert's timing for being at and then departing 34 Fairview. We believe that we're entitled to discovery that encompasses communications around that fact, and there could be, and I would imagine would be, communications in the immediate or close to immediate days or months after an event like this between close family members that would reflect those movements and would be relevant to those movements. However, we recognize that asking for every communication between a parent and their son can't be years. It can't even be the year, 2 years that we've limited ourselves to. So what we're trying to do is have a much smaller scope where we request all communications. Obviously, if there's attorney-client privilege.
So, it's this word all. When you do discovery request, the word all is fine. But if you're going to say all, you got to tie it to either like a period of years or like a subject matter. So Karen's lawyer's trying to be like, listen, we're willing to narrow it down to 2 or 3 years. They're talking about Colin Albert's discussions with his parents about Karen or anything related to John's death or the investigation or the publicity related to the case. And to use the word all is hard. Judge Gilday is going to point it out in a second, but that's what we're dealing with first. Before we get to where Colin is for his civil deposition, we have to talk about the scope of the document productions. Because remember, how are you supposed to do a deposition when someone hasn't given you any documents yet? So that's what we're talking about.
Or something like that, that is, they can make that claim. But we're requesting all communications within a very small period of time, and then the parents would be lumped back in with everyone else for the remainder of the period through December 31st, 2023.
And that small period of time is what?
Our last proposal was January 28th, 2022 through April 30th, 2022.
And why do you suggest it should not be limited to the issues otherwise identified?
Because let's just take, for example, that there's a communication about when you got picked up. That wouldn't relate necessarily to the categories that we have listed here, right? The death of Mr. O'Keefe, the investigation into Mr. O'Keefe, I would say it's relevant, obviously, but you could see communications about timing, who was driving,
how they knew to go pick you up, etc. I'm just giving you examples now, but things that would not otherwise fall within that category. And we're not asking for that with everyone, but we are asking for it as between Colin and his parents.
But you don't believe there's any way to limit the scope of that request to other than all?
We could try to limit it to, say,
Well, I take it if you haven't communicated since Friday afternoon, you haven't been trying, right?
well, as you saw in the communication, I haven't been trying, correct? Because I made a final proposal on Friday that you just referred to, and the response I got was we're comfortable with our last proposal.
Let me hear from Attorney Maddow.
Yes, Your Honor, and I'm maybe at a bit of a disadvantage because I don't believe I was copied on the email correspondence this morning, and if I wasn't, if I was, please correct me, Attorney Rosenberg. But I don't think I was copied on.
Yeah, that's my fault. Your co-counsel was. I apologize for
I'll tell
that.
you what, it'd be helpful if you went and familiarized yourself with it. So why don't we get a copy?
Yeah, here you can.
Right? We'll take a short break. You didn't have to read it in front of everyone.
But it was just forwarding.
We'll take a short break and let you read that so you're up to speed like everyone else is.
Thank you, Your Honor.
All right.
All right.
Had a chance to look at it?
I did, Your Honor, yes, and it was just a transmittal email that included the rest of our correspondence, so I'm comfortable with that.
Okay. So what do you say to whether or not the scope of the request for that limited time period could be reduced from everything to something less?
Yes, Your Honor. Our proposal, which we made to defense counsel, we thought was quite broad and actually should capture information concerning, for example, Mr. Albert's movements on January 28th. What we suggested was that,
Well, they didn't take it that way, I guess, right?
well, they may not have, but what we suggested, and perhaps the court, you can tell me if you think this is fairly broad in scope, but what we've suggested is,
Right now, it doesn't matter what I think. What matters is what the two of you think and
Yeah.
what you can agree to.
yeah. So our belief is that anything that Mr. Albert may have, any communications or documents that he may have relating to the facts and circumstances of Mr. O'Keefe's death or the law enforcement investigation into Mr. O'Keefe's death would encompass any responsive material that would be relevant to this matter. And we're willing to do that. We're willing to do that for a 3.5-year period, and we're willing to do it with respect to every individual that they've asked for communications to or from. And so this, to me, is a little bit of a situation where Ms. Reed won't take yes for an answer. We're actually agreeing to provide anything that we may have relating to the facts of John O'Keefe's death, which is the central issue in this case, or the investigation into his death, which, as I understand it, would encompass what Ms. Reed has claimed is a false narrative surrounding, what the plaintiff would claim is her false narrative surrounding that death. So we are comfortable that frankly, that we've kind of bent over backwards to include a 3.5-year time period of two very broad categories. I offered to discuss search terms with counsel that we could agree to in order to come up with materials that might be responsive. And so, for example, if counsel felt that the category we've suggested would not encompass the timing of when Mr. Albert left 34 Fairview, the way around that is just to agree to a search term that would capture those communications, because we have no objection that those would be responsive and within the category we've suggested. But what we object to is a unscoped request for materials, particularly relating to communications he may have had with his parents, and the very, very broad categories that seem designed to capture information that is not relevant to the issues in this case, which, as I understand it, are one, the facts and circumstances surrounding Officer O'Keefe's death.
Hang on.
Yep.
Give him a chance to respond.
Yes, sir.
You think it?
Yeah, I'm actually going to address what I think Mr. Maddie was about to address. This case isn't just about what happened to John O'Keefe. That's part of the wrongful death claims that the plaintiffs have alleged. But as Your Honor's aware, they have these false narrative, intentional infliction of emotional distress, negligent infliction claims, which relate to, as they call it, the false narrative. That includes the investigators, the investigation, and what Ms. Reed said in both her criminal trial and her other statements, that something happened to Mr. O'Keefe within the house. That is the false narrative. So it can't be limited to just the death of John O'Keefe. I'll give you one example. If Colin Albert had sent a text about Karen Reed, but not about the death of John O'Keefe and specifically the circumstances, I believe that's well within the scope of discovery in this case, and it would be excluded by what Mr. Albert's counsel has proposed. Similarly,
Hi, Flower. This is a civil case. It's so good to see you. Thank you for asking. Flower asked what this hearing is about. This is a civil case where we're relating to the death of Boston police officer John O'Keefe. It's an unknown person who killed John O'Keefe. John O'Keefe's girlfriend, Karen Reed, was tried and acquitted for his death. And now we're in the civil case. There's 4 civil cases. This is one of them in Plymouth Superior Court yesterday in front of Judge Gildea, related to one of the witnesses who was in the orbit of the area where John died at 34 Fairview Road, the home of a Boston police officer named Colin Albert, who happens to be like the uncle of the witness we're talking about. I'm pretty sure the uncle, whose name is Colin Albert. All right, this is the town of Canton, Massachusetts. It's kind of like Midnight in the Garden of Good and Evil, but instead of being about Savannah, Georgia, it's about Canton, Massachusetts, and it ends up involving like Jeffrey Epstein and like drug deals and all this crazy stuff. Like it's wild. But the point is, this specific thing this hearing has to do with a witness named Colin Albert. You're going to find out very shortly, they're going to explain it, that Colin Albert got served with a deposition subpoena and then right away voluntarily enlisted in the Army, went off to basic training, and is now unavailable until until after the discovery window ends in August of 2026. In this case, which was filed by John O'Keefe's family in 2022 or 2023, but which was stayed during Karen's criminal cases when this case. Judge Gildea wants it to just go to trial. He wants discovery to end, and this is a big sticking point because Colin Albert is in the Army. We're going to quickly find out that there's an entire section of the Code of Federal Regulations, which I'm very excited to talk to you about. We can't talk for too long because I want to watch the England match later, and I want to get some very special towel lunch because I didn't eat yesterday. I only ate Chex cereal because I got too excited about all the various hearings that were happening, and now I want to eat a big lunch because I'm very hungry. But the point is, that's not really relevant. Oh, Bill Meyer, thank you so much for those chilies, 6 jewels. I love those jewels. They're wonderful. The point is, this has to do, you're going to quickly come to find out, we're first dealing with the scope of when you issue a deposition subpoena to someone in a civil case, you're in the pretrial process and you're asking them to bring documents and their person. It's like a mandate. It's like the lawyer signs it, but it's under the authority of the court. Okay, it's telling the person you must come to this place at this time and you must bring documents. Okay, and then we're gonna interview you, question you about the documents. Okay, what you're gonna come to find out is that Colin Albert is disputing and trying to object to the scope, the range of document production requests. And then also Colin Albert pulled this really strange series of evasive maneuvers, which I've never seen before in any case, and I can't find any precedent for it anywhere. And I looked this morning for 3 hours. Can't find any cases where anyone has ever done this. The kid, who I've met, by the way, I hung out with him for 4 hours in D&E Pizza one time. He seemed fine. I don't think, frankly, I really don't get the vibe that he's the problem. I just think he knows something that other people don't want him to say. If you want my vibe check. But I can't, that's just my vibe read of it, alright? Colin Albert, okay, gets served with a deposition subpoena in April or May of 2026. And then after getting served, he voluntarily enlists in the Army, okay? Then he goes to Karen's lawyers and is like, I need to reschedule the date of my deposition. And Karen's lawyers are like, okay, we'll do that, okay? They reschedule, and then Colin Albert's lawyers come back to Karen's lawyers and are like, oh, he's gone now. Oh, by the way, he sat for a deposition with the plaintiffs, the O'Keefe family, but he can't sit for your deposition because he's leaving for the Army and he won't be back until after discovery ends. And now we're going to find out that whether this was a sly maneuver or whether someone knew about this, I don't know. There's an obscure section of the federal code that has to do with what you do in this situation. Now, normally, I would say just extend the discovery window, right? The solution here is to just extend the discovery window, because he's at basic training. He will eventually get out of basic training and go on leave. I think, like, almost anyone, I'm not going to speak for the Army. I don't know anything about the Army. I'm just a towel. But I think if you asked a JAG or someone in the Army, what they would say to you is, like, first, like, the first question the Army's going to ask about this, well, they're going to ask two questions. One, why didn't this kid tell us about this? Because it's not just that he was served a subpoena for a deposition. He's a plaintiff in a civil case that's ongoing. Different track timeline on the civil case where Colin Albert's a plaintiff. But the point is the same. Second, I would immediately say, why can't we just extend the discovery deadline? Well, you're going to find that this judge in particular is not going to extend, whether it's for the U.S. Army or Santa Claus or even God himself. Well, that one, I mean Judge Gildea. If God literally appeared, I'm sure Judge Gildea would probably consider it. But I think if Jesus Christ appeared in Judge Gildea's courtroom and said, please extend the discovery deadline in this case, he would say, Jesus, God bless you, no. I think he would literally tell Jesus no. He's not going to extend the discovery deadline. It's like a very firm, even for this one witness. The Judge Gildea has been so firm about this, it reads like gamesmanship. It honestly does. To go to basic training just through the end of the discovery window when you know Judge Gildea is not going to extend it. Frankly, I'm a little concerned. But the point is, we're going to look into now this obscure procedure that gets invoked under the Code of Federal Regulations when you need to serve a civil subpoena on someone who's in the military. Mind you, you're not really serving it. You already served it before they enlisted. So we're in this weird, novel area of law, which the Army is going to hate, where the subpoena's already been served. Now you have to effectuate service again to compel his person to be brought for the deposition because he's in the custody of the Army, quote unquote, in basic training. It's absurd. You're going to find out that there is a way to do this, but the burden ends up falling on Karen to actually effectuate the Army bringing Colin Albert to her for a deposition. They don't release him and put him on a bus. They have to actually bring his person to the deposition, virtually or otherwise. He's in their custody.
If Mr. Albert said something about his relationship with investigators, which is a main part of that quote-unquote false narrative in this case, and that Mr. Albert himself...
Oh, Flower, never a problem. Anytime you have a question, someone else out there might have it as well, so you always feel free to ask. God bless you, and thank you for being here with us. You're wonderful.
...is suing Miss Reed about, that necessarily wouldn't have been included. So it needs to be broader. I'm more than happy to work on search terms with Mr. Albert's counsel. In fact, I think that's a very efficient way to do that. But we need to either agree on, which we haven't been able to, or establish through Your Honor what the scope and the categories that are rightfully at play here are. And then I'm more than happy to work with them on search terms immediately to get to those categories. But I think you can hear that we've still got differences here. And this is not unscoped. You can see we proposed terms, we limited it from the subpoena. There are specific topics that we're asking for, not even of everyone, but only of certain individuals. And those topics are Miss Reed, Mr. O'Keefe, the investigation, the state police and Canton police, the Norfolk DA, and the U.S. Attorney or DOJ. That's not everything under the sun. And to the extent there are categories or individuals where Mr. Albert has...
And someone asked earlier if that covers the FBI. Yes, the FBI works for the DOJ. So when you got to listen carefully, someone on Twitter was asking about this, whether Karen's lawyers were asking about information about Colin talking to anyone, his parents or otherwise, about the FBI. They don't have to say FBI. DOJ, the word Department of Justice, encompasses the U.S. Attorney's Office and the FBI. They all work for the DOJ.
None. As I've said repeatedly, we will accept that. If counsel represents...
Think of the FBI as like the DOJ's police.
Since there were no documents as to, individuals A through D, then we're done with those. And additionally, if there was some extreme burden, right, there was one term or subject matter that was bringing back thousands of messages and it was going to be burdensome in order to go through and produce those, we would have considered that. But we haven't heard any of that in the communications or in the multiple hearings we've now had.
The wonderful and venerated and lovely and beautiful towel girlfriend asks, have we established whether Colin has even made it to basic training yet? Hi chat, I'm here, but I'm listening while I work. You're wonderful, and I adore you, towel girlfriend. I believe we find out in this hearing that Colin is in basic training. That's what we find out, but we'll listen carefully, and I adore you. Just wanted to let you know.
It's just this overall, this is too broad. And we heard, Your Honor, about the time scope. We cut it more than in half. We addressed the terms, but at a certain point, we're entitled to the discovery that we're seeking pursuant to our subpoena.
May I respond briefly, Your Honor?
Absolutely.
So, on the false narrative claim, what Ms. Reed apparently wants to present as a defense in the wrongful death case to the emotional distress counts is that what she said was in fact true. Whatever she claims happened inside the house, to the extent there's any evidence at all that she is at some point going to present to this court, then that would be captured by precisely what we've proposed, the circumstances surrounding John O'Keefe's death. So let's just take a parallel universe where Mr. O'Keefe, as Ms. Reed alleges, went into the house and something happened there. If Mr. Albert has any documents relating to that parallel universe, it would be captured by exactly what we proposed. Because what we are proposing to do is to provide any documents, any communications concerning the circumstances surrounding John O'Keefe's death. So that's number one. With respect to their claim that they should be entitled to any communication.
Hello, we're back. It's not even raining outside. I gotta go check. Maybe the rain knocked my satellite receiver off. If the angle's not right, the connection drops. I gotta go look. Anyway, we're back to the hearing.
Mr. Albert was and is a victim in a criminal case that's been brought against Eden Kearney that, as I understand it, Ms. Reed was at one point a subject of as well. She was not charged, but I'm highlighting this as an example of why Mr. Albert might very well have communications about Ms. Reed that have nothing to do with the issues in this case. They would want us to produce a communication in which Mr. Albert pointed out that Ms. Reed had a dog or a cat, which has no relevance to this case, or that Ms. Reed had launched a defamation campaign against him, which also has no relevance to this case. It may have relevance to some other case, but it has no relevance to whether or not Mr. O'Keefe, the circumstances surrounding his death, which again, we agree. Anything relating to that, they should get. Anything relating to the false narrative claim, which again, has to do with the circumstances surrounding John O'Keefe's death, they should get. We've agreed to give that to him for a 3.5-year period. So I'm not understanding yet why the very, very broad scope, which I think counsel would acknowledge, would necessarily result in communications that are not relevant to anything here, why the court should bless something like that when what we've proposed, I think, broadly encompasses all of the claims in this case.
Just 2 quick points. One, the false narrative is not just about the death of John O'Keefe. The part of that alleged false narrative is the cover-up and conspiracy side of things. That necessarily came after Mr. O'Keefe died. So it's inaccurate to say that we can capture anything relevant to this case by stopping on January 29th, 2022 or thereabouts. Secondly, as we're all aware, this is a third-party subpoena. At a certain point, a third party is not in a position with standing to argue about specifics of relevance. They have standing to argue about burden and undue burden on a third party, and we recognize that, and that's why we made changes. But a relevance objection like this is misplaced at this point. We are entitled to put document requests that, in a subpoena that are reasonably intended to gather relevant topics. I think a term that relates to communications about Karen Reed and about John O'Keefe is well within that scope, as Rule 26 uses the phrase relevance.
I'm not trying to get the last word, Judge. I just had a couple of things I wanted to add.
You got all afternoon. Go on.
First, if what she's claiming is that there was a grand conspiracy and a cover-up, okay, the date range we have proposed, to the extent there were any communications in furtherance of this conspiracy and cover-up, would more than adequately capture them. We're proposing a 3.5-year period. And so if, as Ms. Reed apparently purports to believe, there was a grand conspiracy that was occurring in 2022 and 2023, and there were communications about the circumstances of Mr. O'Keefe's death at that time, and the fact that all these people, dozens and dozens of people apparently, were conspiring, then those will be produced in this case under the subject matter that we have scoped here. I also, just on the relevancy thing, we've cited authority in our brief, Your Honor, that the party propounding the discovery has the burden of showing some relevance. And so this is absolutely an issue that the court should have to decide when considering what is an appropriate scope here. Obviously, you don't have to decide what information and evidence may be admissible or not. That's not the issue. But the reason that that inquiry about relevance exists and is important for the court to conduct is because otherwise parties would engage in fishing expeditions all the time, which I know this court doesn't want, we don't want, but which Ms. Reed seems to be seeking.
One example of something that would not be limited to the about circumstances of Mr. O'Keefe's death. There are allegations that Ms. Reed has made in multiple lawsuits, including this one, that certain of the individuals in the house deleted phones or deleted contents of phones or devices. That obviously happened well after Mr. O'Keefe's death. If there was a text, and I'm not saying it exists because we don't know if it does, but if there was a text between Mr. Albert and someone else who was in the house that said, get rid of your phone, that would be very, very, very relevant to the alleged false narrative claims and the conspiracy that Ms. Reed has alleged, and it would absolutely not be covered by the circumstances surrounding Mr. O'Keefe's death. There are plenty more, but I think that highlights the concern.
So they say it's included, you say it isn't.
Well, they say generally it's included, but if it were included, if the answer was...
It's stated on the record in 2 areas that they're going to produce what you're looking for.
Right, but as Your Honor is aware, it's not our job to give them the specific examples of documents that may exist in their client's possession, custody, or control. It's our obligation to give them a sufficiently limited amount that it doesn't impose an undue burden on them, but categories, and that's what we've given. They've taken those categories and significantly narrowed it. And I recognize that Mr. Maddie, and I believe Mr. Maddie, that the 2 examples that he's commented on today, he says would fall in their narrow, very narrow categories, and that's great. But I think there are tons of other things that would be very relevant that would fall well outside that, and I don't think that's proper.
Anything else?
No, thank you.
Anything else?
All right, so we're going to move to the next motion. Before we do, though, I just want to quickly take a look at the Turtle Boy motion to impound the motion to dismiss. That just went up. If you've been paying attention to Proctorgate, the abhorrent text messages from Michael Proctor involving Sean Good, the former sergeant of the Canton PD, and other people, including the husband of Meg Kennedy, who was Sandra Birchmore's guidance counselor and also the best friend of Jen McCabe. All right, very odd connection there. And then also there was another man on the text chain who was a former Canton cop who got arrested in a sex for hire ring bust in 2013, and then months later in 2014 was hosting a fundraiser with Colin Albert. This is Michael Proctor's friend, hosting who's very racist, hosting a fundraiser for John O'Keefe's orphaned niece and nephew, who John had not even, I think, adopted his niece and nephew in 2014, in early 2014 at that point. You had Michael Proctor's friend, just a few months before, arrested in a sex bust, who was a Canton cop, at his CrossFit gym with Kevin Albert, who's brothers with Brian Albert and Chris Albert. Kevin Albert's a Canton cop, hosting a fundraiser after John O'Keefe's niece and nephew are orphaned, double orphaned actually, because their mother dies tragically from cancer in November of 2013, and then their father dies. So their mother was John's sister, and then their father dies in January, I believe it was January 12th of 2014, and they're left orphans, double orphaned. And the people hosting the fundraiser for them are Michael Proctor's racist friend who got busted in a sex for hire ring, Kevin Albert, who was involved in both the Sandra Birchmore case and the Karen Reed investigation related to John's death. And it's hosted at this CrossFit gym. It's wild. It's just, and then in the Proctor's messages, he's also talking to the husband of Meg Kennedy, who was Sandra Birchmore's guidance counselor, and Sandra Birchmore, as we know, according to the federal government, was murdered by former Stoughton cop Matthew Farwell on February 1st, 2021 at 9:27 p.m. And the Canton PD, including Kevin Albert, collected three key pieces of evidence between February 4th and February 6th, 2021, including that Matthew Farwell was the man on the surveillance footage at Sandra's apartment at 9:27 and also 9:53 p.m. on February 1st, 2021, and that further Matthew Farwell was the man who moved Sandra Birchmore into her apartment, and then further that Matthew Farwell had gone around to Sandra's friends at the school where she was an administrative assistant, telling people that he had abused Sandra since she was a child and groomed her through the Police Explorers program, which was run by Robert Devine through a charity called Learning for Life, which is connected to Jeffrey Epstein and Maxwell. And Jeffrey Epstein went to Stoughton on July 8th and 9th of 2014, while Michael Morrissey, the Norfolk DA, and Robert Devine were hosting a basketball camp. Making me all mad. So Sandra Birchmore, while being the Canton police are investigating her death, collect those three pieces of evidence, and then the third piece of evidence is that Matthew Farwell told friends of Sandra that he was going to, quote, take care of the problem herself if Sandra was going to insist on carrying her unborn 8 to 10 week old baby boy to term. All right, and then according to the federal government, Matthew Farwell went over to Sandra's apartment and hung her from a door. Somehow, Brian Tully's State Police Detective Unit, that was the same unit that investigated Karen Reed for John O'Keefe's death, and Aidan Turtleboy Carney, the journalist, and Tiffany Overstreet for that matter, although Brian Tully wasn't the detective lieutenant, it was Mark Sir at the time, I believe, but the point remains the same. You're going to quickly come to find out, ladies and gentlemen, that there's something off about this unit, because John Fanning, who was Brian Tully's first officer, which means he was second in command of the unit, below Tully but above Sergeant Uri Buchanan, used to work in Stoughton. And John Fanning wrote a report clearing Matthew Farwell for the death of Sandra Birchmore and her unborn baby, only for the federal government to impanel a grand jury in August of 2023 and then indict Matthew Farwell for the first time related to Sandra's death in August of 2024, and then the second time in August of 2025 related to the death of her unborn 8 to 10 week old baby boy. Thank God there's a law that allows them to charge that now. In any of it's actually a new law. Thank God President Trump helped pass that law. Now, in the context of that investigation, it also is interesting to note that there was a civil case out of Norfolk Superior Court filed by Sandra's family related to her death. And in the context of that case, Sandra's family retained an independent forensic pathologist by the name of Dr. Baden. Dr. Baden is the husband, and he was the forensic pathologist who basically exposed that the state medical examiner and the state police covered up Sandra's death, and it was not the result of self-harm. Fascinatingly enough, Dr. Baden is the husband of Linda Kenny Baden, who's the host of Justice Served TV, which does excellent coverage on the Turtleboy case, the Karen Reed case, and the Sandra Birchmore case. And fascinatingly enough, Linda Kenny Baden's co-host is a man by the name of Michael Bryant, and Michael Bryant was looking into Jeffrey Epstein in 2019. How do I know this? Because Jeffrey Epstein caught Michael Bryant looking into him, and then Jeffrey Epstein had his PI spying on Michael Bryant. All right, so there's something pernicious that links the Tiffany Overstreet case. Tiffany Overstreet was a woman who was dating Robert Devine in 2013. Robert Devine was a married man who was then the deputy chief of the Stoughton Police Department and also in charge of the Police Explorers program where Matthew Farwell groomed Sandra Birchmore. All right, now, In that context, Tiffany Overstreet threatened to reveal her relationship with Devine to his wife and other people. Jeffrey Epstein, according to his bank records, visits a IKEA and then a gas station. Well, he spends like $354 at the IKEA and then $33.74 at the gas station. And then he spends some time in Stoughton on July 8th and 9th of 2014 and then goes to a Dunkies the next morning. All right. This was after he flew in from his island, went to Manchester, went to a Starbucks, then a Dunkies, went to visit Ghislaine Maxwell, then drove down 95 and through the split and then from New Hampshire and then went to Stoughton, the billionaire's paradise of Stoughton. No, absolutely not. And the area he went is in the same area as this restaurant, it was actually a restaurant chain. There were three of them, one in Stoughton, one in Dedham, and one in Boston. And all three of them, I have reason to believe, potentially could have been involved in like a brothel network that was tied into Epstein and Maxwell. Why do I bring this up? Because immediately after Epstein goes to Stoughton on July 8th into the 9th of 2019, the same time when Michael Morrissey and Robert Devine are hosting a youth basketball camp through the Police Explorers program type network, all of a sudden, within 3 months, Michael Morrissey's state police unit is bringing up like ridiculous fake charges on Tiffany Overstreet for violating an RO that Devine somehow got, but told Overstreet wasn't in effect so that they could bait Overstreet into violating it, so the RO, so they could arrest her, haul her in, and then charge her, much like Michael Proctor threatened to do when he said he was going to stick a nightstick up someone's rectum and then plant coke on him to bring him in. All right? And I think this leads to the implication, along with a newly revealed text message in the Stoughton Internal Affairs Investigation report about the Sandra Birchmore case, indicating that someone had threatened Sandra Birchmore in the months before she died or was murdered in February of 2021, saying that Sandra needed to pay back the money that she owed to the girls at the dorm suite. Sandra lived alone in an apartment in Canton. Where was there a dorm suite? I don't know, potentially in the restaurant that was in the area of the place that Epstein was visiting in Stoughton on the day that Morrissey and Devine were there. And also, how did Robert Devine become deputy chief in Stoughton to begin with? And why did Carmen Ortiz arrest two of his superiors on federal charges, paving the way for Robert Devine to become deputy chief and then run the Police Explorers and Learning for Life program, helping Epstein's Gestapo network, in my opinion, operate a drug and human trafficking network in plain sight in Massachusetts, where the girls were kept basically in like a living cage with the threat of retaliation via false criminal charges or interference through the probate court or family court or otherwise, in order to keep them working within this network and quiet about what was going on. Hashtag I'm a towel. I forget why I got all mad about that. I just got really, really mad. I don't know. I forget what led me. Don't even get me started on that road. But anyway, I was watching Turtle Boy this morning, and he said the name Tiffany Overstreet. Now, he wrote about this in 2022, so I don't know if it's like always on the tip of his mind. But when he said her name, he was like, I don't know that name. And then he was like, wait a minute, I think I do. He's going to go read his article about her now. It's actually tagged. There's only one article. It's about Sandra Birchmore, but Tiffany Overstreet's in the article. He's going to put it all together. He's going to realize he actually cracked this entire case. It was the Epstein Files plus Turtle Boy's research about Tiffany Overstreet that helped me put this all together. And then I found the B-Fit team of the state police. Yeah. It's more intense than a modern Black Mass redo. And all I know is nobody better touch any of those birdies. All right? They're free now. I don't want to hear anything about any pimping or anybody being forced to work or any of that nonsense. Stop buying prostitutes. You're enabling human trafficking. You're making me all mad. All right. So let's go to Turtle Boy's motion now. So Turtle Boy filed two motions. One has to do with trying to get more communications from the Proctor files, Michael Proctor's phone. And then second, Turtle Boy's filed a motion to impound unredacted copies of a supplemental motion to dismiss, which means we're also going to get a redacted version, which will have all the good stuff kind of hidden. But really, if Rosemary Scapiccio could get an unimpoundment order from Judge Doolin on these files, then why can't Aiden Carney? That's what I have to say about that. So, Mr. Carney comes before the court, hereby requests an order of impoundment of the today filed unredacted version of his second motion to compel Michael Proctor's communications with incorporated memorandum and unredacted exhibits. Mass rule of impoundment. Okay. He has also filed a redacted version with no impounded material present for the public docket. I want to see it. Where is it? Kyle, we need that other document. Come on, Kyle. As grounds, defendant states that all redactions are previously impounded material and the instant motion simply respects prior impoundment orders and maintains the status quo. The unredacted portion is filed under provisional impoundment, seeking the court's approval to impound for foregoing grounds. Mr. Kearney does not waive his objections to the protective orders, impoundment, and his prior motion to vacate impoundment orders. He maintains his position set forth in his prior filings on the matter, that the information may generate adverse publicity does not support impoundment or protection from public view. So, there we go. I had a feeling eventually we were going to see, much like Rosemary Scapiccio's move, we were going to see Mr. Kearney move to unimpound his motions related, because remember, Proctorgate started because of Karen Reed filing a civil case in Bristol Superior Court. Proctorgate expanded because of Rosemary Scapiccio getting permission from Judge Doolin to unimpound her motion to dismiss in the Miles case criminal case in Norfolk County Superior Court. Now, Aiden, in his criminal case in Norfolk County Superior Court, is asking for the same relief that he's going to eventually, I imagine, that Rosemary Scapiccio got when the Miles King motion to impound was unimpounded, or motion to dismiss was unimpounded. The public deserves to see what's in that motion. We'll see a redacted copy soon enough, but Aiden already said on his Bus Stop Live this morning not to expect any bombshells about Proctorgate because all the good stuff is still redacted. So what we're waiting for is the court to compel Proctor to give, the Norfolk DA to give all of the Proctor files to Aiden Kearney, and also I imagine we'll eventually see Aiden Kearney try to get the court to allow the motion to dismiss to be unimpounded so we can see what the hell is going on. Rosemary Scapiccio pulled it off. We need Judge Doolin. Hashtag Judge Doolin to the rescue. All right, let's go back to the Colin Albert hearing, though, and I'll continue to monitor for document updates today. You can tell I like court documents. I like covering lots of things. Court documents are something that just make my heart sing, though.
Not on this. I just wanted to briefly update you about a different motion. Are you?
Hey, Buck, do you want to jump in? Or you
No, I'm sorry. Just one other.
Stay seated.
I don't want to be well enough. I don't want to steal Attorney Buck's thunder. There is the outstanding issue, Your Honor, about Mr. Albert's availability for a deposition. I know we've started discussing the scope, and so I'm happy to discuss that whenever it makes sense for the court.
Go right ahead.
Okay.
All right, here's the good part. We're going to listen to this, and then we're going to look at the section of the Code of Federal Regulations. How I found this, either the lawyer didn't know about it, or what I'm thinking is the lawyer did know about it, and this was a tactical trap to get Colin out of the deposition.
Your Honor, since last week, we have made inquiries of the United States Army at Fort Jackson, and we've also done some research about how a deposition of an active duty service member would be arranged. And bottom line up front, Mr. Albert, as a trainee in the United States Army, is under the command and control of his commanding officer. And so if Ms. Reed wishes to take his deposition, yes, sir.
Just curious, did your research include a subpoena that already was served?
Well, Your Honor, so I guess the question you're raising is, if Mr. Albert had been served with a subpoena.
She had been.
Correct, prior to entering the military. And let's presume for a second that that subpoena remains valid, even though I know you know we take a different position. And he then enters the United States Army in the interim. The United States Army has custody of his person. And so if the deposition is going to take place after the date upon which it was originally scheduled, April 29th, I think.
Yes, Chair Barron, you're going to find out that in CFR, the CFR we're going to read, it does cover that. We're going to talk about that in a second. We're going to let Colin's lawyer get through his full position, which I don't think is very well informed, frankly. Clearly, he actually says to Judge Gilday he doesn't know what he's talking about. Well, I did the research, and yeah, he doesn't know what he's talking about.
And the only way for that deposition to occur is with the consent of the United States Army. And there is a process for that. What would happen is Attorney Reed's counsel, Ms. Reed's counsel, or we could help facilitate this process, would reach out to the staff judge advocate at Fort Jackson and let them know that there is a request for a non-party in civil litigation pending in Massachusetts to take Mr. Albert's deposition. And I've never done that before, so I don't know exactly how that process would play out, but I know that that would be the necessary first step. Now, I've called the staff judge advocate 4 times at Fort Jackson between last week and this morning. I've left 4 messages. I haven't heard back. I've also consulted with a colleague who's a former JAG officer with 2 combat deployments. She advised me that the process would definitely include the staff judge advocate at Fort Jackson, may also include the Army Litigation Division, which is the main legal component of the United States Army, and that process would just have to play out. But the reality is neither we nor Mr. Albert have any authority to present him for a deposition while he is in basic training. He's not given any leave. He's not given any visitation at Fort Jackson. He has very limited access to telephone. His day starts at 4:30 in the morning, ends at 9 p.m., and it's entirely structured. And the basic combat training program is phased, so that phase 2 builds on phase 1, phase 3 builds on phase 2. This is a 10-week program, after which we understand he will be granted leave. And so what I asked counsel last week was, listen, if Judge Gilday were to permit, given the burden that forcing Mr. Albert to submit to a deposition while he's in basic training would impose, if Judge Gilday were to permit an enlargement of the scheduling order for the sole purpose of conducting this deposition after Mr. Albert completes basic training, and if the other defendants, if the other parties agreed to that, would you? And they said no. And I asked them why, and they said they had strategic reasons. And what it made me wonder is why they hadn't taken his deposition in the many, many months during which this case has been pending. And
No, listen to me, he's gaslighting. The only tactical maneuver here was someone getting served with a deposition subpoena and then joining the Army.
why they didn't take his deposition when he actually sat for it 2 weeks ago.
Well, the answer to the latter question is they didn't have the documents, and they had said in their discussions with you that they wanted the documents before they took the deposition.
And they don't have the documents now, Judge. And so what I'm saying is, given the burden that this would place on Mr. Albert, and the fact that he's already been...
Excuse me for interrupting, but the burden is self-imposed.
Wait a minute. Replay that. Play it back, Judge.
Given the burden that this would place on Mr. Albert, and the fact that he's already been...
Excuse me for interrupting, but the burden is self-imposed because there was a subpoena, and as I've said a number of times, a subpoena has to mean something. And there was also some agreement between the attorneys, and the words and actions of an attorney need to mean something too.
Your Honor, let me just say a couple things in response. First of all, I am not aware of any agreement between attorneys. I've read that email traffic. I was not the one negotiating this, but I've read that email traffic. And that deposition was canceled. And if they want to take a deposition of him on a different date, they can issue a subpoena for a different date. But it is my understanding that there was no agreement. I also want to just say one thing in response to the idea that Mr. Albert has imposed a burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to serve his country, and tells everybody that he's going to be available for a deposition in a compressed period of time, and one party decides not to take advantage of that, and then he enlists and subjects himself to basic training, and the idea is that he was supposed to organize his life choices as a non-party witness around when Ms. Reed might ultimately decide to take his deposition, I don't think it's fair to suggest that he's imposed this burden on himself. He's undertaking a burden to serve our country, made himself available for a deposition, and now all we're saying is, under these circumstances, wouldn't it make sense to conduct this particular deposition when the young man has completed his basic training, and after which we've resolved all these issues about documents?
Deposition wasn't canceled, Your Honor. You can read the emails yourself. I'm the one who wrote it. It said the deposition will be rescheduled when we resolve the pending dispute over the documents. Mr. Maddie points out we still don't have the documents. That's because they still haven't agreed to produce the documents, and we need to be back here with Your Honor for a second hearing to get what we believe is a significantly narrowed scope, which we proposed last week after Your Honor provided some feedback on the initial scope. Also, subpoena is not a request. Mr. Maddie said a request that he be deposed. It's not a request. It's a court order. The case law is clear. A subpoena is a court order. And obviously we're not looking, as I've said, to impose an unfair burden. We recognize that the service didn't happen in time and immediately said, yeah, that's too tight. We will reschedule it. To now argue that by saying we will reschedule it, which is exactly what the email says, that we canceled the deposition and rendered the subpoena ineffective is, I think, absurd. And it flies in the face of the obligation that a party serving a subpoena has, as Your Honor pointed out, to work with the recipient in order to do it in an efficient way and not impose an undue burden. I also haven't heard any of this until right now. We've been conferring. I heard that it's difficult, but the specifics of the steps that they've been trying to take, we haven't heard. I would have a couple questions. One, was Mr. Albert asked to identify this proceeding and the subpoena that he had received when he enlisted in the military? If he was, does that impact his ability to come back to Massachusetts to appear pursuant to the subpoena that was issued in this case? At the end of the day, everyone here, I think, respects a decision to serve our country, but the timing of this is extremely relevant. We served the deposition, the subpoena. We had the back and forth where we said we would reschedule. We waited 3 weeks for a response on the documents. We got an email that said, in effect, he's available for the next 13 days and then he's gone. That's not appropriate, and that's not in compliance with a subpoena that's issued by counsel through this court. And if there's something we need to do in order to make it more possible, I'm more than willing to hear what we can do to help do that, but there's been no proposal. It's just he can't do that. And to address briefly this idea of extending the scheduling order, as Your Honor is aware, we've been working over the course of many months now with the understanding from Your Honor that that is a hard deadline and we need to do everything we can to get everything done in that deadline. And we've made tons of decisions in reliance on that, and you've effectively kept us to that. We've got depositions, many this week that we're taking. Plaintiffs have taken a number. Things are moving forward. It'd be completely unfair for us to now have the deposition that we noticed early on in the schedule be put way back, in fact, after the deadline that we've all been operating under.
Your Honor, I don't understand any prejudice to Ms. Reed or her counsel for taking this deposition 3 weeks after the August 17th deadline. I'm not understanding what the prejudice might be. I do understand and respect the need for court-ordered deadlines. Here,
I don't know what their strategy is. I don't know either.
That being said, whatever their strategy was, apparently meant that they weren't going to take his deposition in the first year in which this case was pending, and then decided that they would take it, and then when there was a dispute about documents, our position is they canceled it. Our position is that there is not a valid subpoena to be enforced right now. However, given the importance of working collaboratively with counsel, we are going to continue to do that. And if the court tells us that we need to find a way to pull Colin Albert out of basic training, we will go ahead and see what that process is and pursue it. But I don't think that's fair to him. I really don't. And I don't think Attorney
he should have known that process. We're going to look at it because I found it very quickly.
Rosenberg thinks that's fair to him. When we could take this deposition just a few weeks after, one witness, then he will have finished basic combat training, he will be on leave, you won't need to go through this.
New this morning, the state's Supreme Judicial Court has struck down the rent control ballot initiative proposed for this November in Massachusetts on the grounds that it relates to religion, religious practices, or religious institutions.
Process, which I'm just now learning about trying to persuade the United States Army that they should release a witness for a civil proceeding in Massachusetts when they don't even let him have his phone. However, if that's the course of action that the court wants us to take, we will work with Attorney Rosenberg to try to facilitate that. I just think it's highly unfair to this young man.
To be clear, I do think I understand the burden it imposes, but as Your Honor said, it's a self-imposed burden that he knew he had the subpoena. He decided to enlist when he decided to enlist, and that resulted in him being unavailable less than 2 weeks after he could give the other side notice. So this is not someone who was already enlisted, who we tried to serve a subpoena or say served a subpoena when someone was back on leave, and then they ended up back under the control of the military. That's not what happened here. The timing is set out very clearly in the communications that are part of the record. And I think not only is it fair under the circumstances, I think it's required, and I would ask the court to order Mr. Albert's counsel to present him, and I represent to you that we will work with them and do what we need to do to assist that.
Well, first of all, he was available for a deposition. He was. He sat for a deposition in this case. And secondly, Judge, in all deference, if you order us to make efforts to arrange his appearance at a deposition, we will do that. But we do not have authority to produce him on our own. The United States military does.
I think it would be a great idea if you found out more.
We'll continue to work on that. I was hoping they would take my calls. They didn't. But
No. We're pausing at 3201. Hold on. We'll come back to 3201. Listen to me. He's playing games. I found the relevant section of the regulations. It's actually on Karen. It's not on Colin's lawyers using this as a dilatory tactic. He's smart, but he's hoping Karen doesn't realize it's her burden. We're going to listen to 32 CFR Part 516, which is the codification of Army Regulation 2740. And we're going to find out exactly what you need to do in order to subpoena someone, even if they're already under subpoena, to get someone to show up for a deposition when they're in the Army, basic training or otherwise. Let's take a listen. I'm a towel. British reporter towel, take it away.
Conversation. Hey, look, I found the exact process on Army Regulation 27-40, 32 CFR Part 516, by which Colin Albert will be forced to comply with Karen Reed's deposition in the John O'Keefe civil case. That wasn't so hard. Let's start here. Section 516.10 Service of Civil Process within the United States. Policy. Department of the Army, DEA, officials will not prevent or evade the service or process in legal actions brought against the United States or against themselves in their official capacities. If acceptance of service of process would interfere with the performance of military duties, Army officials may designate a representative to accept service. DEA personnel sued in their individual capacity should seek legal counsel concerning voluntary acceptance of process.
Okay, so let's listen to what this says. We're not talking about the first part. He wasn't sued in his capacity, and the U.S. wasn't sued. He wasn't sued in his capacity as a soldier or anything. We're talking about DA personnel, Department of the Army personnel, of which he is. He fits under that definition. Back. Avatar. We're back. Hello. All right. So picking up where we left off. Let me give you the exact definition of DA personnel. Colin Albert fits under that definition. It is defined in different places. You can find it at 38 CFR Section 3.1, which defines it as all military personnel within the regular Army, the Army Reserve, and the Army National Guard of the United States. All right, so we're talking about, you got to know how to read CFR. It's the Code of Federal Regulations. We're talking about, he's not being sued here, although he is a plaintiff in another case, but he's like, we're talking about someone who's in their personal capacity, but in the Army. So we're not talking about that first part of the section. We're talking about the second part. Now we're going to listen to this next very operative part.
B. Request for witnesses or evidence in civil proceedings. See subpart G to this part. Well,
now,
what does subpart G say?
Now notice, it doesn't say requests for witnesses or evidence in civil proceedings wherein the U.S. is a party. It's talking about requests for evidence or witnesses in civil proceedings related to the Department of Army personnel. Okay, that's what we're talking about. My pleasure, beautiful towel girlfriend. This research is important. So let's take a listen. Right, we're now, so it's self-referential. We're going from 516.10B now to 516.40 subpart G. Okay, let's begin.
Subpart G, Release of Information and Appearance of Witnesses Scope. Section 516.40 General. A. Introduction. This subpart implements DOD Directive 5405.2, see Appendix C to this part and 32 CFR Part 97. It governs the release of official information and the appearance of present and former DA personnel as witnesses in response to requests for interviews, notices of depositions, subpoenas, and other requests or orders related to judicial or quasi-judicial proceedings. Requests for records, if not in the nature of...
Pause. So again, this is the scope of what we're talking about. Witnesses, past or present DA personnel, Department of Army personnel, as witnesses in response to requests for interviews, notices of deposition, subpoenas, and other requests or orders related to judicial or quasi-judicial proceedings. Doesn't say anything about where in the United States is an official party, etc. Now, we're going to go to another section that's unrelated, where what happens if you want records and there's no legal proceeding. We're going to listen to it, but it's not relevant to what we're talking about.
Requests for records, if not in the nature of legal process, should be processed under AR 25-55, the Department of the Army Freedom of Information Act Program, or AR 340-21, the Army Privacy Program. This subpart pertains to any request for witnesses, documents, or information for all types of litigation, including requests by private litigants, requests by state or U.S. attorneys, requests by foreign officials or tribunals, subpoenas for records or testimony, notices of depositions, interview requests, civil cases. Criminal proceedings, private litigation, or litigation in which the United States has an interest.
So that is, so it's talking about any of it, but that's completely different. And then it's saying this subpart pertains to any request for witnesses, documents, or information for all types of litigation, including requests by private litigants, so this is separate than the thing before. Requests by private litigants, by state or U.S. attorneys, requests by foreign officials or tribunals, subpoena for records or testimony, notices of depositions, ding, 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 interview requests, civil cases, criminal proceedings, private litigation, or litigation in which the U.S. has an interest. That's an or. It's not applying litigation in which the U.S. has an interest to all of those previous categories. This is the relevant section of the CFR. And we're going to find out Karen has the burden to effectuate this. Let's take a listen to the policy.
Section 516.41 Policy. General Rule. Except as authorized by this subpart, present or former DA personnel will not...
Except as authorized by this subpart.
Except as authorized by this subpart, present or former DA personnel will not disclose official information, see Appendix F, glossary, in response to subpoenas, court orders, or requests.
Oh, that's not relevant anyway, because we're not asking about Colin Albert's official information he might know.
B. Exception. Present or former DA personnel may disclose official information if they obtain the written approval of the appropriate SJA, legal advisor, or litigation division.
Also not relevant.
C. Referral to deciding official. If present or former DA personnel receive a subpoena, court order, request for attendance at a judicial or quasi-judicial proceeding, or request for an interview related to actual or potential litigation, and it appears the subpoena, order, or request seeks disclosures described in or above, the individual should immediately advise the appropriate SJA or legal advisor.
So it does not involve any official information.
Or request. If the SJA or legal advisor cannot informally satisfy the subpoena, order, or request in accordance with sections 516.43 through 516.50 of this subpart, he should consult with litigation division.
That's not relevant.
Requester's responsibilities.
Pause. That's not relevant. So that part up there only applies when we're talking about official information. Now we're going to a completely new subsection. Now remember, Karen is the requester. She's the moving party seeking the deposition of Colin Albert.
D. Requester's responsibilities. Individuals seeking official information.
But she doesn't want official information, so this also doesn't apply.
Individuals seeking official information must submit, at least 14 days before the desired date of production, a specific written request setting forth the nature and relevance of the official information sought. Requesters can be referred to this subpart G. Subject to section 516.47, present and former DA personnel may only produce, disclose, release, comment upon, or testify concerning those matters specified in writing and properly approved by the SJA, legal advisor, or litigation division. See United States Ex. Rel. Tohey vs. Reagan, 340 U.S. 462, 1951.
Oh, I love Tohey v. Reagan. That is like, what, 28 CFR 16.26 through 27. It's a fascinating section of law. It's like when Karen used it and the state used it to get information from the feds about an investigation during like a concurrent state level criminal proceeding. But anyway, so that's not relevant, though. It's fascinating, but Karen's not seeking official information. Now, Karen is also not seeking information in the context of litigation in which the U.S. is a party. But let's listen to that subsection anyway.
E. Litigation in which the United States has an interest. If a subpoena, order, or request relates to litigation in which the United States has an interest and for which litigation responsibility has not been delegated, the SJA or legal advisor will coordinate with litigation division under Section 516.42.
Not relevant.
F. Motions to stay or quash subpoenas. A subpoena should never be ignored, and an SJA...
Oh, wait a minute. This part is very relevant. So, again, these are all subsections. They're not related to each other per se. Okay, some apply to proceedings where the U.S. is a party, some apply to official information, some just apply generally. So let's listen to this part.
F. Motions to stay or quash subpoenas. A subpoena should never be ignored, and an SJA or legal advisor should seek assistance from litigation division or the U.S. Attorney's Office whenever necessary. If a response to a subpoena or order is required before a release determination can be made or before litigation division or the U.S. Attorney can be contacted, the SJA or legal advisor will do the following. 1. Furnish the court or tribunal a copy of this regulation, 32 CFR Part 516, Subpart G, and applicable case law, see United States Ex. Rel. Tohi vs. Reagan, 340 U.S. 462, 1951. 2. Inform the court or tribunal that the requesting individual has not complied with this chapter, as set out in 32 CFR 97 and 516, or that the subpoena or order is being reviewed. 3. Seek to stay the subpoena or order pending the requester's compliance with this chapter or final determination by litigation division, and 4. If the court or other tribunal declines to quash or stay the subpoena or order, inform litigation division immediately so a decision can be made whether to challenge the subpoena or order. If litigation division decides not to challenge the subpoena or order, the affected personnel will comply with the subpoena or order. If litigation division decides to challenge the subpoena or order, it will direct the affected personnel to respectfully decline to comply with the subpoena or order. See United States Ex. Rel. Tohi vs. Reagan, 340 U.S. 462, 1951.
Wow!
Classified
Okay,
as
stop.
Wait
a minute! So, the response, what the Army's gonna do, hi Joy, hi Jenny Lou, how are you all? So what the Army, hi Aaron, what the Army is gonna do, based on this, and they don't really have a choice here, they're supposed to move to quash the subpoena. With this is just a general rule, not regarding when the U.S. is a party, just specifically the general rule. They should move to quash, indicating non-compliance with 32 CFR 97 and what's the other one? 516, which is this. And then, or if Karen somehow did manage to comply with this subpoena, then, oh, hold on, frame drop, 1 second. Frame drop. We're back. If Judge Gildea will not quash the subpoena or stay the subpoena, only then will the Army order Colin to appear for the deposition. And if the Army does choose to challenge if they do not choose to challenge it, then Colin has to appear. If they do challenge it, after the court declines to quash or stay the subpoena, so I guess if the Army indicates it's going to appeal, then they're going to direct Colin not to comply. That's the operative section. That's it, in a paragraph. And the burden really is on Karen here. I did not, Joy. I'll have to take a look at that. I'm not an expert on the paperwork, but I definitely want to learn more. Now, I got to say here, this is fascinating to me. So it seems like I'm going to guess someone read this. Like, lawyers are smart. I think somebody's faking Judge Gildea out. I don't know if it's Colin's lawyer or what. But, lawyers would know about this. And if you really dive deep into it, this is the operative, sort of section here. The Army, by rule, has to, even if Karen somehow miraculously complied, which she might have, with the requirements of 32 CFR 97 and 516, they still are supposed to either ask to stay or quash on the grounds that the subpoena is being reviewed. And then, if Judge Gildea refuses to do that, then they're supposed to decide internally whether they're going to challenge the denial of the motion to quash or stay or not challenge. If they don't challenge, then Colin gets produced. If they do challenge, they order him not to comply. Now that, ladies and gentlemen, is how you dive deep. We got it. I think this is actually, I think by law, I'll do more research. This is a novel case. I can't find any case law on it. I'm sure there's something out there about like an Army member who was active service and like came back or was on leave, but nothing about basic training, and certainly nothing where someone entered basic training after being served a subpoena. But like based on my review of this, by law, the Army has to ask Judge Gildea to stay or quash this subpoena. Somebody figured this out. It's genius. It's not genius level lawyering, but it's really smart. It's very, very smart. Do you realize what's happened here? It's like Collins, in essence, I don't know who figured this out, but if I'm right about this, then the Army's required by law to object to the subpoena. Or at least move to quash or stay it on the grounds that they're reviewing it. Are you kidding me? What? What? Something ain't right. Something's not passing the sniff test with this. That's such a specific, it's a compelled series of events, if I read this right. And there's no other section of the law on this that I can find. This is the only part. And I've talked to some people who know some things, and I can't find anything else. And like, if the Army is presented with this and they read it, a lawyer in the Army is going to move to stay or the deposition or quash the subpoena. Based on my read of this, it's compulsory. There's no option. So, that's wild. Now, that doesn't mean, so Judge Gildea will probably read this too. That doesn't mean Judge Gildea is obligated to respect that. He can deny the motion to quash or stay enforcement of the subpoena. But, like, even then the Army can be like, well, we want to challenge it and direct Colin not to comply. It has, like, multiple layers built in to give him cover. That's some genius level lawyering. I don't know who did that, but that's genius. Absolute genius. Whoever wants this kid they may have actually found a loophole. I don't know if I were sitting around in a JAG office and this came on my desk and we were all sitting around, like if I was talking to my commanding officer, and we were all lawyers, and like we got to this part, I'd be like, wait a minute. Are you telling me that we have to buy... Frame drop, 1 second. Like, no way. I'd be like, wait a minute. There's no way this 18 or 19-year-old kid knew that we would have to do this. Like, what lawyer figured this one out? I'm blown away. Very rarely does something like this, because I read it earlier, but I didn't, when you read the CFR, I don't think people understand. When you read statutes, like, every word matters. Like, you gotta read it, like, top to bottom, or you won't get the context or understand what it's saying, or what it applies to. But that's a crazy subsection, and we're not talking about classified information in that subsection, because they would say it when it talks about specific things. It says it. We're not talking about cases where the U.S. is a party. It would say it. Are you kidding me? Wow. It's stunning in the scope. Like, I'm blown away. I've been introduced to a level of lawyering I didn't even think existed. I'm disgusted by it, frankly. I don't like it. I think this is very manipulative. It would be different if they had served Colin when he was after he enlisted, but he enlisted after he got that subpoena. It's very obvious. This seems like brutal gamesmanship. Hello, Sue. It's so good to see you. Welcome. I mean, and why would Colin... It's clearly not Colin doing this. Someone, is really trying to keep that kid from being deposed, or at least deposed now. Nunya is getting closer and closer to convincing me that there's something up here. If Judge Gildea rules that if this plays out in such a way where Colin never gets deposed in this case, we'll know it's a bad job. I'm sorry. Whether it's because the Army intervenes, and by the way, Karen's got to get on this immediately. Her lawyers probably figured this out, but they have a burden here. They're going to be up against the Army. The Army has no choice, I believe, but to object. Or at least say they're reviewing it. That's why they're stalling everyone. It's going to be embarrassing for the Army. Somebody called in a favor or something with this kid. I don't get how he filled out those forms. I know DUI guy went through it. I'm not an expert in those forms. I do have one of the forms. I think it's an SF86. We'll finish the hearing in 1 sec. I want to get lunch in a little bit. We'll go for a little bit longer. But I do have this form here that the Army, I think, makes people fill out. Now, I didn't get to take a look at the DUI guy's overview, but let's just take a look at this SF86. Oh, Aaron, God bless you. Aaron says, thank you for your coverage of Karen Reed. You are doing the Lord's work, and Jesus sees you and loves you. Keep going, towel friend. Oh, you are so kind, Aaron. You are so kind, Aaron. God bless you. It is my honor to be able to help, and I feel empowered every day by the compassion and support of so many of you wonderful towel friends. Oh, God bless you, Aaron. That was so nice. I didn't even put a goal up today because I was I was just focused on this. But God bless you, Aaron. That was so nice of you. Thank you for your support. I guess I should remind folks, if you want to support Towel Channel, buy me lunch, buy me a coffee. There are various ways to do so. You'll find them in the chat. I try to do this every 2 hours. It's only been an hour and a half. But yes, you can do the super chats. You can become a member. You can like the stream. You can subscribe. Neither of those cost anything. There's also other ways to donate. Hashtag buy towel lunch or a coffee, and you can do that via Cash App, # Grant Smith Ellis, Venmo at Grant-E1, or PayPal, paypal.me/Grant Ellis. You can also scan either of those fancy little QR codes up on the screen, and they'll help you do just that. Hello, Towel Mom Bunny. How are you doing? Hi, Kofi. Did you know Kofi's a dog? Kofi, we're reading court documents today. I think you're probably going to, we're actually reading Army documents and watching court hearings. You're probably going to get a little bit overwhelmed, so... and then Julia says, Jesus knows you are... Oh, wait a minute. I, under no circumstances, Julia, are you going to invoke the name of Jesus in order to engage in that kind of manipulative behavior? If you want to cover for the mystery man, all right, you can do it somewhere else. I am not going to have anyone coming up here and invoke... This is almost as bad as when that soldier hit Jesus in the head with a sledgehammer. Ma'am, how dare you invoke the name of Jesus to try to manipulate people into not asking questions about what happened with John O'Keefe's death. I'm disgusted. I'm offended. I thus name the dishonorable member named Julia. You've been removed from the house permanently. How about them apples? I'm disturbed. Hashtag, how dare you take Jesus' name in vain. I'm mad. Making me all mad. That's not going to stop us from reading this form, though. Whatever is in this form that Colin Albert had to fill out must be really interesting. Now we're going to read it. How about them apples? Have a good day, Julia. God bless you. All right. So, what is the SF86? Let's see. Seems this is what you fill out when you apply to be in the military. All right. All right. Let's see. Let's take a look. So what questions do you have to answer when you fill out an SF-86? All right. Let's see. What do you need? All right. I'm not the best at this, but we'll take a look. So you need a U.S. passport, certificate of citizenship, all right, proof of legal status, okay, employment history, and personal references, personal residence, 3 personal references, educational institutions. Oh, hold on. Frame drop. 1 second. I'll wait for the frame drop to end. 1 second. We should be all right. There we go. All right. The background check form when you join the Army. Got it. Thank you very much. Non-conversational. That was very, very helpful. I love your username. Ironic. Because you were very conversational and very erudite and helpful. All right, so we're going to take a look at some of the questions. Let's see what exactly this entails. All right. Yes, yes, yes. All right. Uh-huh. 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 Places you have lived, where you went to school, employment and unemployment record, okay, contact information, selective service number, 3 people who know you well. Don't list your spouse or former spouse or other relatives or anyone listed anywhere on this form in other sections. Marital status, who do you cohabitate with? This is someone who you share bonds of affection, obligation, or other commitment, as opposed to a person with whom you live with for reasons of convenience. Example, a roommate. If applicable, complete the information requested about your cohabitant. Okay. That's weird. Okay, now your relatives. Okay. Enter the detail for each relatives, whether they served with any foreign government or military. Foreign contacts. You have to indicate whether you have or had close or continuing contact with a foreign national within the last 7 years with whom you or your spouse or legally recognized civil union, domestic partner, or cohabitant are bound by affection, influence, common interest, and or obligation. I hope Colin Albert didn't know any damn Canadians. Frickin' Canadians. Oh, goodness. Let me see. Foreign activities. Foreign financial interest. Oh, goodness. Non-conversational says you'll fill this in when you become a JAG. That would be interesting. I don't know if I qualify to be in the military. Even as a JAG. I'm 37. I'm probably a little old. I probably have to pass the bar to be a JAG, too. And I don't know if I'm trying to do that. But I'd be a consultant. Can you be a private consultant to the JAG officers? That would be great. All right. Foreign businesses, professional activities, and contacts. All right. Okay. Psychological and emotional health. Okay. Section 21. Indicate whether or not a court or administrative agency has ever issued an order declaring you mentally incompetent. 2. Indicate whether or not a court or administrative order has ever ordered you to consult with a mental health professional. 3. Indicate whether or not you have ever been hospitalized for a mental health issue. 4. Indicate whether or not you have ever been diagnosed by a physician or other health professional with psychotic disorder, schizophrenia, schizoaffective disorder, delusional disorder, bipolar mood disorder, borderline personality disorder, or antisocial personality disorder. 5. Indicate whether or not you have had a mental health or other health condition that substantially adversely affects your judgment, reliability, or trustworthiness, even if you are not experiencing such symptoms. Okay. Note that mental health treatment and counseling in and of itself is not a reason to revoke or deny eligibility for access to classified information or for holding a sensitive position, suitability or fitness to obtain or retain federal or contract employment, or eligibility for physical or logical access to federally controlled facilities or information systems. Seeking or receiving mental health care for personal wellness and recovery may contribute favorably to decisions about your eligibility. All right, let's see. Illegal use of drugs. Okay. Financial record. Indicate whether or not you have filed a petition under any chapter of the bankruptcy code within the last 7 years. Whether you must also indicate whether you have encountered any other financial issues within the past 7 years and will be specifically prompted by additional questions. You'll be prompted to complete additional required sections based on your responses. When listing past due debts, include reasons for the status, amounts owed, and whether or not you have satisfied the issue. If you're working with the creditor, please explain when you're going to pay your debt. Validating. Okay. So there was nothing in there about, maybe I missed it, but there was nothing in there about like whether you're like subject to a civil subpoena. Okay. All right. So, yeah, I mean, there must be another sort of thing you go through, but there's nothing in there about what happens when you're subject to a civil subpoena. Let's go back to the hearing now. I'd like to finish our hearing. We stopped at 30 minutes and 12 seconds. 32 minutes and 1 second. I got the numbers messed around there. But yes, let's take a look. I want to finish our hearing from where we left off. So we need to go to the 32 minute and 1 second mark. And then I'm going to eat my lunch after that. We'll see if the new Turtle Boy document goes up. If it does, before I eat my lunch, I'll read it. If not, I'll read it another day.
And secondly, Judge, in all deference, if you order us to make efforts to arrange his appearance at a deposition, we will do that. But we do not have authority to produce him on our own. The United States military does.
So he's got to know the code I'm talking about then, because he's right. Only the Army can order Colin to be deposed, and there's a specific way to do that. Yes, I am going to eat lunch, Silent Dogs. It will be a real lunch, not a fake lunch. Hashtag towel lunch. Just want to say thank you again to Aaron, by the way. God bless you for your support of Towel Channel. You're wonderful. Lunch is important. Silent Dogs, imagine if the dogs didn't get lunch. They'd be all made.
We'll continue to work on that. I was hoping they would take my calls. They didn't. But we will continue to work to find...
The dogs are not allowed to have cigarettes. Coffee, I don't know. But you can't be giving the dogs cigarettes now, Silent Dogs. What... I don't know what to say to that.
Out more about how that...
Now, you, if you know, I don't condone smoking, but, I can't stop you. But no giving the dogs cigarettes.
Process might play out. I'm confident that the initial step would be reaching the staff judge advocate and informing them person to person of the status of the situation. I've left that information.
Yeah, so what actually happens is you tell them, and then they have to file a motion to quash or stay the deposition. So, why are we delaying this? Let's get it done.
My messages, but I haven't been able to reach anybody, and I will continue to do that if that's the court's recommendation.
You might not want to use the words, the other side canceled the deposition. Maybe couch it in terms that it's disputed.
Karen should be contacting the Army. Karen has rights under the federal code. We already know what the Army's going to do, okay? Now I know. I can see the future. Hashtag clairvoyant towel. I know exactly what's going to happen now. The Army's going to file a motion to quash or stay. Okay? So let's just get them to do it. And Colin's lawyer is clearly trying to delay. So why are people, the trap Karen's lawyers might have fell into, is they let Colin's lawyer go ask the Army. No, Karen's lawyer should be doing that. And they need to get the Army to file that document, because the only way the Army's going to compel Colin's attendance is if Judge Gildea denies the Army's motion to stay or quash the subpoena. Hashtag I'm a towel.
It is disputed, and that's our position.
You're wonderful, Sue. God bless you.
Thank you, Judge.
Thank you.
Your Honor, can I briefly just update you on that other motion I was talking about? It wasn't that. You asked at the end of the last hearing what other motions were coming to you. There's one that relates to Mr. Matt. Well, I think Mr. Maddie's representing them, but the other individuals.
No, John, he's not jumping up.
Yeah, I know. I don't want to. Well, he's representing some of them in the defamation case.
Yeah, I don't want to
hesitate.
I don't want to take too many liberties with the court's
involvement. I was trying to be careful, but we've got deposition notices and a motion to compel for Brian Higgins. Excuse me, not Brian Higgins. Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe, that's coming to you very shortly. We discussed that earlier. Separately, we had a deposition scheduled of Lieutenant Brian Tully of the Mass State Police. We served Lieutenant Tully with a subpoena May 5th.
Speaking of Brian Tully, I have breaking news coming across the wire right now from Kyle Sharkey that Brian Tully is now working as an instructor for Advanced Police Concepts. Advanced Police Concepts, ladies and gentlemen. I don't know what Advanced Police Concepts is. I'll look it up right now. Advanced Police Concepts Company. Is a nationwide law enforcement training company that specializes in professional development for law enforcement, investigative, and correctional staff. Founded and led by CEO Michael Schentrup, the firm provides modern evidence-based training curriculum from over 100 years of combined active policing experience. Oh, who are we going to find this guy's connected to? I swear, if we find a connection between that firm and Five Stones or any of those guys, we'll know. We'll know. I'm a towel. I'm going to show you this information right now. It was just reported on by the venerated reporter towel, Kyle Sharkey. He's a towel. He's a smart towel. So there's the information just breaking on the wires right now from Kyle Sharkey. You now can see it up on the screen. Yes, ladies and gentlemen, Brian Tully, the recently resigned member of the Massachusetts State Police, who literally, fortuitously, in a moment of historical serendipity, was just mentioned. We're going to hear that Brian Tully is trying to evade his deposition. Let's take a listen. Well, now we might have more information as to what Mr. Tully's doing. He's clearly not unavailable because he's now working with Advanced Police Concepts. All right? But let's take a listen, and then we'll read that bio.
And it sought documents June 1st and June 11th, so we did a better job with the service.
We'll run this back.
We discussed that earlier. Separately, we had a deposition scheduled of Lieutenant Brian Tully of the Mass State Police. We served Lieutenant Tully with a subpoena May 5th, and it sought documents June 1st and June 11th, so we did a better job with the service. His counsel asked to reschedule for July 8th. We rescheduled. And then the day after our hearing last week here, we got a motion to quash asking the court to say he doesn't have to show up at all, doesn't have to produce any documents. Came out of the blue. They didn't confer with us. We don't know why there would be a change when we accommodated the date. So that we served an opposition to that motion the same day we got it, which was last Thursday, and we urged them to please file it with this court as soon as we can. I don't believe that's happened based on the docket, but I just wanted to give you a heads up that that is on its way.
The four parties you talk about, there's a motion ready to be filed?
Yeah, I believe the opposition is due today.
It's my understanding that we'll be serving our opposition, or that those individuals to whom the motion is directed will be serving their opposition today, I believe.
And we'll aim to file it tomorrow.
I do represent a number of them in the defamation case, Your Honor. It's the same situation as we have with Mr. Albert here. I'm not admitted to represent them as witnesses here.
You're probably going to be here on their behalf next time.
Well, if Mr. Tuxbury's still on vacation, I probably will be, yeah. With your permission, of course.
When would you like to do that?
Before we jump to that, the plaintiffs have two forthcoming motions that, contrary to public belief, I have other cases that have depositions too. Personally, I don't, just for the record, to be clear, I don't want to convince the U.S. Army of anything. But the plaintiffs have forthcoming motions to compel Aidan Kearney, as well as further answers to interrogatories from Ms. Reed. I believe the opposition was just served the end of last week.
Oh my word! New texts have dropped. New screenshots have just dropped. Hold on one second. New screenshots of the Proctorgate texts have dropped. Howie Carr has them. Oh, it's the attachment. Oh my word, it's the actual messages. Oh! Oh, wow. Oh, my word. What's going on? This is wild. Okay, give me 1 second. I'm a towel. We have the actual Proctorgate, like, screenshots. This is crazy. Oh, my goodness. I can't believe this. Howie Carr just uploaded them. I have the document. Proctorgate texts, screenshots. It's the actual attachment. Oh, my word. I can't believe we have this. This is great. It's a great day for America. We have the actual screenshots of the text. I'm getting them right now. Give me 1 second. I am a towel. These could be incredibly vile. I want to warn you. I'm not going to say the words out loud. Okay. It's uploading right now. It's a big file. It's going to take a second. It's pretty much done. Oh, my word. I can't believe this is happening. You're here for it live. Howie Carr just dropped them. Proctorgate has expanded. Oh, well, you've already heard some of the summaries, but we actually have the text. Oh, my goodness. It's what is it, Tuesday? It's a Tuesday surprise. Good thing you all were paying attention. Oh, my goodness. Here they come. All right, I have the PDF. Let me share it. Hold on. Manage access. Change. Anyone with the link? Oh, this is wild. I can't believe this is happening. I'm going to see this. Oh, wait a minute. What do they say? Oh my goodness. Oh my word. Oh, wow. Oh my word. Oh, I can't believe what I'm seeing right now. Oh, what's going on right now? Breaking. Oh, my word. I can't believe this is happening while I'm live. Proctorgate has expanded. We have the actual screenshots of some of Michael Proctor's horrifying messages with his friends that are, to put it lightly, the most bigoted statements I have ever seen in a court document. This is from the Miles King docket. Oh boy. Oh my word. Link. I have the link too. I got it. You gotta know what you're doing. I'm a hell. I can't believe Proctorgate has expanded. I have ever seen. We have the actual screenshots. These friends that are to put it, not out it lightly. The Miles King docket. That's horrifying. I can't. Oh no. How do I undo that? Oh no. Oh no. How do I undo? Oh, damn it. Maybe I cut it instead of pasted it. No. Oh, damn it. I gotta write it again. Proctorgate has expanded. We now have the actual screen shots of messages sent between Michael Proctor and his friends that are, hands down, that are some of the most bigoted messages ever seen in a court filing. Link. Alright, I had to rewrite it. It's fine. Oh, hold on. Actual messages. This is wild. Hello, am I still here? Am I back? I'm back. We have the actual messages. I can't believe it. You're going to get to see the actual messages. I'm going to read them. That's it. That's it. We'll listen to the section about Brian Tully, and then I'm reading these messages. This is wild.
The office Friday and today, so I believe that both will be filed either tomorrow or Wednesday.
When would you like to do those?
Hi, Larson. I'm glad the goats are building a wall.
We're going to have 4 now. I think we're going to have those 2. We're going to have ours as soon as Lieutenant Tully's counsel files his 9A package, and then our motion. So I'd say as soon as we can, because
Or I was going to suggest right after the 4th of July holiday, possibly. You know, we have a robust deposition calendar, as Your Honor's aware.
I don't know, the court schedule, we could do July 2nd to get it, because Lieutenant Tully's depositions to be the 8th. We've got that set aside. Everyone has that set aside.
I believe we're scheduled for a 30v6 on the 2nd.
I think that's the one that he just emailed and said. They asked.
We were double booked that day.
Ah, okay.
So there's 30v6 of C.F. McCarthy's.
How about the 6th? It's the Monday after. I don't think we have a depot.
I'm not aware of anything currently scheduled for the 6th.
This is my only case, so don't worry about it.
Just like all of us, Your Honor.
Hey, look, Mike, you'll see.
All right, so all they deal with from there is scheduling. We're looking at the Proctor messages. They actually got released. The attachments, I can't believe they were released and unimpounded. I have them for you now. Here they are. We're going to take a look at them. These are the actual Proctorgate messages. I am shocked. I tell you, I've seen some things in my day. I did not think we would see the actual Proctorgate messages. Oh my goodness. Here we go. I want to be clear. I believe these are censored. Okay, Rosemary Scapiccio did censor some of the more horrifying remarks. I do not condone any of this language. I condemn it in explicit terms. And some of the stuff that is probably in there is going to horrify and shock you. This is Proctorgate. And you're here. It came out 60 seconds ago. This is the whole file. Oh my word. Oh goodness. Oh, this is bad. Okay. So, I think this is from Michael Proctor. This is for the first time you are looking at what the messages looked like. This is from August 21st, 2013 at 9:16 a.m. Proctor, I believe Proctor says, Jesus, 99 messages and a B word ain't one. Some thoughts on what I read over PB's comments. Taking a... Oh my goodness. Michael Proctor was on the toilet telling his friends... He says having a bowel movement, but does not use those words, on the toilet, so this will be long. 1. Nirvana is legit. Hated them when I was a pimply-faced cub, but their unplugged CD is effing incredible. Grown to appreciate their music in Bloom is a personal favorite. Didn't he call himself Bear? So he was a cub at one point? Bro, that's a weird language. Because, like, den mother, cub, I'm concerned. 2. The double standard, reverse racism that N-words get away with absolutely infuriates me. God forbid some stand up for the victims in those stories, says Michael Proctor, and rallies for justice against the, quote, black perps. Proctor then says, then you would see Jesse Jackson and Al Sharpton surface talking about how those N-words are a product of their environment, and Proctor says, and have been shunned by society and wasn't their fault. And then he says, F you. 3. The Canton 10X Club closed? Wow. Get those former members to home base. What's the Canton 10X Club? What the hell? It was a beauty salon? And a day spa? And a gym? Why is Proctor talking about that? It was called the 10X Club. It's closed now. It was in Canton. It looks like it had various things, like don't throw your dirty towels on the floor. I am so confused. Please do not leave your dirty towels on the floor, was the sign in the business. What? I don't know what's going on. I'm already deeply concerned. Oh, I don't like this. 4. That's no good. CHS, I imagine that's Canton High School, plays Stoughton twice. Leave it as just the Turkey Day game. He's probably talking about high school football. Has more meaning that way. Whitey had an epic performance one year at that game. Got carried out on the Legion Thanksgiving morning, blacked out drunk. Is Whitey one of their friends? I hope that's not, I hope that's not the other Whitey. Oh, that would be bad. Aaron Murphy, yeah, what's home base? I need to make a tweet about this. I need an adult. I'm concerned. What's home base? What were these people doing? Why does this case get worse and worse? You think it's going to end, and then it just gets worse and worse and worse. Here's the 10X Club for you. Oh, I don't like anything about this. I have a lot of concerns. No. Why? Can someone please explain why in 2013 Michael Proctor was telling his friends that the former members of Canton's 10X Club needed to join home base after the 10X Club closed? I have questions, and Proctorgate is expanding. I have questions. I have lots of questions. I'm mad. I just wanted to eat my lunch. How has this happened? I can't believe this has happened. I'm blown away. I'm shocked. I'm appalled. I'm offended. I knew it. What the hell is home base? I knew it. I'm mad. What is going on right now? Somebody get me an adult. This is only the first freaking page. I'm mad. I'm mad. I can't believe these have just... I can't believe we're looking at the actual text. Okay. Okay, then someone says, oh, and a sausage, egg, and cheese, I think this is Proctor, on a croissant is the best sangi at Dunks. Horrible for you, but incredible. Load that thing up with ketchup and you're ready to rock. I think he's using slang for sangria, so he's like, sangi? Maybe it's a slang, maybe it's a language I don't know. Sangi? Sandwich, maybe? Hello, it's me, Andrea. Good to see you. Free the First Amendment. You probably want to stay here because these texts just dropped. These are all the Proctor texts. We're now in August of 2020. Not all of them. All of them that Rosemary Scapiccio released. There's 200,000 of them. These are 36 pages of them. But this is the beginning of the slow drip. All right, so I think that's innocuous. The next message says, Globe's preseason has St. John's Prep as #1 squad in the state. Then someone says back, Larry Kennedy. So this is the husband of Meg Kennedy. And Meg Kennedy and Meg Kennedy is Jen McCabe's friend, and Meg Kennedy was Sandra Birchmore's guidance counselor. So Meg Kennedy's husband says back, St. John's best player transferred, and I was at the Legion, beat everyone in a 50-yard dash. And then Leahy, so we don't know who Leahy is yet. His name is just Leahy. And he says, a bagel that's twisted and cooked with cheddar cheese. Okay. And then Proctor says, I am hot 80% of the time, regardless of the weather. This is on September 4th, 2013. Then, on September 4th, 2013, Proctor says, usually do iced when I am hung balls. So he was talking about being hungover. Usually do iced when I am... He was calling like a sandwich from Dunkies a good hangover cure. Usually do iced when I am hung balls. Hot venti bold from Starbucks and a fat A-word Kodiak after. What's a Kodiak? Wait, what? Oh, a tobacco dip. Got it. Menino is right. Who's Menino? Menino. Who the hell's Menino? Menino comments Detroit 2013. In 2013, Boston Mayor Tom Menino caused a major controversy when he stated during a New York Times Magazine interview that to fix Detroit's financial and municipal crisis, he would blow up the place and start all over. Oh! So Proctor's like, Mayor Menino is right. Detroit should be destroyed along with places like Flint, Michigan. They are breeding grounds for N-words to run wild. Oh, God. And then Sean Good says back to that. No. That was on 9/4. Then the next year, on November 24, 2014, Sean Good says yes. And then Sean Good says, I think so too. Or no, Larry Kennedy says, I think so too. And then Larry Kennedy says on November 24th, 2014, protesters are saying heavy police presence is arrogant and disrespectful. November 2014 protests. Oh, this was the Michael Brown Jr. case, and this was the day that the jury decided not to indict white police officer Darren Wilson for the fatal shooting of Michael Brown Jr. That's why I needed the dates. I couldn't figure out what they were talking about just from the motion. But the dates give me everything I need. All right. Wait a minute. We have all of the people on the chain. They are Foley, Cookie, Good, Kevin Foley, Fargo, Trendy, Leahy, Larry Kennedy, and Hammer. And in this message, Proctor says that this is the one where he says that there are 9 whitey people and 3 N-words on the jury. Then Proctor says to all of those people, I was planning on tying up an N-word and dragging him from my bumper through the streets of Randolph. And this was on January 18th, 2016. What happened? What happened in January of 2016? I guess he was just bad that day. Okay. Now Larry Kennedy, so this is the husband of Jen McCabe's friend, Meg Kennedy, I believe, who was Sandra Birchmore's guidance counselor. Larry Kennedy says, Spike Lee, and then he quotes, how is it possible for the second consecutive year all 20 contenders under the actor category are white? And let's not even get into the other branches. 40 white actors in 2 years and no flavor at all. We can't act, WTF. So it looks like Larry Kennedy's like prompting the discussion by highlighting this Spike Lee tweet. Hello, Kim. It's so good to see you. Yeah, I guess I could change the live description. Hold on one second. Proctorgate expands with new Michael Proctor text shown for the first time. Hold on. For the first time. Plus Karen Colin hearing. All right, I've updated the title because Proctorgate has expanded. I just wanted to eat lunch, hang out with Towel Girlfriend, watch England in the World Cup. I got my Man City jersey on. But, you know, duty calls. I'll get through it soon enough, Towel Girlfriend. I got this. I'm a 10. All right, so I updated the stream description so now people will know we're reading Proctorgate. All right, now, Proctor says back to that message. No, excuse me. Good says back to that message. Apparently not all Black Lives Matter. Then Proctor says, we ride solo and will always ride solo. Stupid, probably can't staff 2 troopers. What? Huh. You got it, towel girlfriend. So that was odd. Oh! Thank you to the person who sent a Cash App. You're wonderful. It's my pleasure to be able to help in any way that I can. You're all wonderful. Hashtag towel lunch. I'll put off my towel lunch for a little bit longer. Okay, so that was odd. And then, oh, I see. They're talking about how there was unrest. We're back in November of 2014 now. It's a little out of order. And now Larry Kennedy says all cops will be targets. They're talking about, this is weird. They're like making each other think that there's a threat to police because of racial unrest. And then Proctor then says, ha 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 ha, cookie, let's get some horses and white sheets and burn a cross in the Arboretum. This was November 24th, 2014. So this was in response to the white police officer not being indicted for the Michael Brown shooting. And then, what's the context here? On November 1st, Proctor says he hopes someone gets R'd in the A by a gang of 300-pound N-words. So who is he talking about? Hold on. What happened on November 1st, 2016? I can figure this out. Hold on. What happened on that day? Maybe it was the day before. Who are they talking about? Oh! I think I got it! I think it's Casey Hickox. Marine judge imposed limited restrictions, but explicitly rejected state officials' strict bid to quarantine nurse Casey Hickox, who had recently returned from treating patients in Sierra Leone, and there was a risk of Ebola spreading. I wonder if that's what it's about. That happened on October 31st. Oh, it's actually 2016. Scratch that. We got to go for this. I just want to be clear. This jumps out of order. Scratch that. It's probably not Casey Hickox. They're talking about a woman, and they're saying they want something bad to happen to her, and it's not 2014. It's hard to read the date. It's 2016. So we're looking for something that happened October 31st, 2016, or November 1st, 2016. All right. How about November 1st? Nope, I have no idea. It seems random. There's no major. So with some of the other ones, there's major political events that happen. Was obviously an election happening like right around this time. It could be Hillary Clinton, but there's nothing on October 31st, 2016 or November 1st, 2016 that's like very like clear that they're talking about a certain woman. But I'm going to figure this out. Kevin Foley says back, mega N-word C-word. And then Proctor says on November 9th, 2013, hey, N-word, go fetch Bear some pizza and wings. Larry Kennedy laughs to that. And then Hammer must have like reacted to it, but there's nothing in the message. And then Larry Kennedy says, best thing I've heard in a real long time. This didn't scan correctly. Page 10. This wasn't from his iCloud. This is a forensic extraction. That's not from an iCloud. That's from the shared app group folder within the private full zip variable containers subdirectory. Fascinating. Yeah, that was not an iCloud backup. This is all from an extraction of a phone. All right, and this one, Sean Good says, this is January 10th, 2014. Yes, the first Cruise movie I liked in years. Fargo says, Leafy, should we hang out and listen to Rocket Queen tomorrow afternoon? Proctor says, evening blank holes. I feel I need to weigh in on the movie debate here. I agree 100% with Good on the Chestnut Hill Superlux level. I will never see a movie anywhere else. And then Proctor says, no N-words, obnoxious kids, and ample room to spread out and float some air biscuits, which are farts apparently. Great menu and prompt service. And then, hey, oh, Proctor didn't like the Irish. Oh, Proctor didn't like the Irish. Hey, Leahy, how would you feel if the potato famine wiped out your people? Being wiped out by a potato would be embarrassing. Oh, no. Oh, God bless you. O-H-I-Y-O chick, Ohio chick. Oh, I'm going to click heart right now. Oh, you're so wonderful. I'm going to be able to get my towel lunch. Wait a minute. Isn't Aiden Irish? Ladies and gentlemen, that's it. Michael Proctor disliked the Irish. We've got our proof. I knew it. Michael Proctor disliked the Irish. I have confirmation. I found Michael Proctor's bias against the Irish. That's it. He even hated the Irish. Breaking in a shocking turn of events. It can now be revealed that former State Trooper Michael Proctor, among other bigoted biases, also made anti-Irish jokes regarding the potato famine. I believe Dr. Turtleboy may be Irish. That sounds like bias to me. I knew it. Bias against the Irish. They're biased against the damn Irish. That's what it was the whole time. I knew it. It was not just, there's a lot of bigotry involved, but it was the anti-Irish sentiment, ladies and gentlemen, that is going to get Turtleboy his ability to get those Michael Proctor messages. That sounds like bias to me. Aiden's class of people to me. Hold on. Let me get this link. Alright. Source. Page 12 of 36. I knew it. We have discovered the anti-Irish bias. Oh, Erica is going to be furious. Paulie D is going to be so mad. You don't understand. We were going to free Derry. Now we know why Derry was never free. It was Michael Proctor. Michael Proctor hates the Irish. Clearly. Watch him turn out to be part Irish. It doesn't matter. You can be biased against yourself. It still counts. Even if he were part Irish, it won't save him. All Aiden needs, in my opinion, is to make the argument that there's an anti-Irish bias, and it's right there. He made an Irish potato famine joke. This is an outrage. I demand somebody contact the Irish president. I want to speak to the Dolly. I demand redress of these grievances on behalf of the Irish nation. This is completely unacceptable. The Irish people have been besmirched. They have been defamed. They've been insulted. Proctorgate has hit home in the country of Ireland, ladies and gentlemen. Yes, interestingly, the Proctor and the Good families both come up in the Salem witch trials. But listen, I have seen some things in my life. I've seen a lot of biases, seen some disgusting messages, truly, from Michael Proctor, Sean Good, and other people on this text chain. But let me just be clear. I never thought we would get to the point where Michael Proctor was expressing bigotry against the Irish. Haven't the Irish been through enough, ladies and gentlemen? Yeah, Proctor might be an English name. But my point is, this is anti-Irish bias made manifest. I demand that the Irish government take up this cause, and in response, I demand that 3 sections of the city of Derry, specifically Creggan, the Bogside, and the Moor, be turned over to Ireland. Yep, we're going to leverage Michael Proctor to free Derry, and no one's going to stop me. Someone tell Erica. I have a plan, ladies and gentlemen, and that plan is to liberate those 3 specific areas of the city of Derry in order to fulfill the dream of a free Derry, and that's my price. Michael Proctor is bigoted against the Irish, and I demand satisfaction. My grandfather was part Irish. He was a very good man. He served in the Navy. Then he was a fire chief. And I'm offended on... Well, he's not with us, God rest his soul. I'm offended on Grampy's behalf. That's it! All right. This has really hit home for me now. This is pushing the limits of my journalistic impartiality. He's decided to take on the Irish. This is one step too far. That's it. I'm mad. Can't just be making bigoted remarks about all the people of Ireland and about the potato famine, no less. I'm mad. I'm all mad. So good to see you, Aaron Murphy. How you doing? I love those Irish clovers. That's great. John and Elizabeth Proctor were tried and convicted of witchcraft. I wonder if Michael Proctor is related to them. But either way, my point is, we found this is the smoking gun. You know, I was listening to Turtle Boy talk earlier. He was like, listen, Proctor was bigoted against a lot of people, but Turtle Boy didn't see this one coming. You know what I'm saying? He didn't think that Proctor was bigoted against the Irish, and based on the potato famine, no less. That's mocking genocide. This is an outrage. Listen. We need to speak to the Irish Prime Minister and the President. We're gonna have to talk to Sinn Féin. Somebody called Jerry Adams. I have things to say about this. I'm really mad. That's it. Yeah, I'm a little biased. Can you tell? My grandfather was part Irish, okay? And he never got to go to Ireland because he was afraid of planes. I tried to explain to him that they weren't going to fall out of the sky. He was just not convinced. He was just really not convinced. So anyway, he never got to go to Ireland. But the point is, I'm taking this up as a cause celebre. It also happens to fit very nicely into Aiden's legal argument that, you know, Michael Proctor was bigoted against Irish people. That's it. That's it. I knew there was a smoking gun in there. I didn't expect it to be a bigoted joke about the Irish potato famine genocide. This is entirely unacceptable. And as much as I use humor to try to, you know, temper my anguish, I'm mad. Can't be making jokes about I just can't believe you could have made any other joke. But, you know, he screwed himself on that one. Turtle Boy's going to get all the messages now. Irish people are a protected class. Listen, they went through the potato famine. That makes them a victim of some kind of genocide. They're a protected class. Good enough for me. Everybody on board? All right. Irish people are now a protected class, and if you have a problem with it, you have to leave. Listen. I absolutely will do that for you, towel girlfriend. Your people are absolutely a protected class. I gotcha. But, you know, I haven't seen Michael Proctor directly come at you yet, your people, in the messages, but I'll let you know. But as to, you know, this is very operative to Turtle Boy's point. Really, this changes the game for him. Because that's, like, Rosemary was not going to put that. This is an appendix to the filing that Rosemary Scapiccio filed in the Miles King case. It's not really relevant that Proctor was mocking Irish people in the Miles King case, but it is in Aiden's case, because Aiden is Irish, I'm pretty sure. Oh, thank you, Brooklyn Piola. I actually wasn't I didn't know this was going to happen. We were just kind of, like, informally watching yesterday's Colin Albert hearing. If I had known that Proctorgate was going to expand, especially about the Irish, I would have, like, you know, made a bunch of posts about it and all that. But no, this broke in the middle of the stream. I saw Howie Carr post about it 60 seconds later. I got the document, downloaded it, re-uploaded it so people could just look at the primary source. Howie didn't even screenshot all the messages in his article. I don't even think he realized that there was anti-Irish bias in there because it's 30-something pages of very fine text, and it's difficult to read. But the point remains the same. Yeah, I do. You can let your friends know about Towel News, youtube.com/@GrantSmithEllis. A lot of good ways to support. You can like the channel. If you like the channel while the stream's live, it lets people know that, you know, it's good. You can comment. That helps people find out about it. You can subscribe. You can become a member. All good ways to help Towel News. God bless all of you. Let's continue. So then we know that... All right. Then someone says back, although it's unclear, or maybe it's Proctor again talking to someone else named Michael. Michael, we could use them N-words, says this person, as dartboards. Now, I think this is Proctor, so there must be another Michael in the group, because every other person that's not Michael Proctor is identified by, like, a tag after their name. All right, so someone says back, I would love that. So Larry Kennedy says back, I would love that. Perfect world. Leahy says, God can hear you too. Well, hey, Leahy, you were the only one who realized. It turns out it was a lot more than God. God can hear you too. How prescient. Whoever the hell Leahy is, hey, bro, you totally figured it out. It was a lot more than... Maybe, you know what? Maybe God was listening. You know, Now that I think about it, maybe God was listening. Well. Well. Right after Michael Proctor made abhorrent anti-Irish jokes about the potato famine and about using, quote, as dartboards in the Proctorgate files, one of his friends said, God can hear you too. Well, that was a prescient insight. God heard, and he was mad. It took him like 10 years, but let's just say I think God was waiting for his opportunity. I can't speak for God. But, if God was listening to what Michael Proctor was saying, I think he was mad. Someone says this is guessing it could be Dennis Leahy. Not really sure who that is, but they are identified here as Leahy. God can hear you too. Oh my goodness. That dude was basically saying, like, how can you commit this stuff to writing? You're both out of your mind. He was the only smart one of the group. Alright, let's continue. I can't... This one seems to be an empty message from Hammer, which could be like a reaction. Okay, we finally got it. November 17th, 2023 is the infamous It Should Be Punch an N-Word Day in Canton, says Michael Proctor, today out of Retribution. And then he says, any slur, any S slur you see blasted in the face. Oh, he sends an attachment. He sends an attachment. And we can't see what it is. And then Leahy says back, can we confirm that this actually happened? And then Good says negative. Domestic between two blacks. What? 11/17/2013. Huh. What are they possibly talking about? And then why does Good correct him to say it was a domestic between... Domestic... I can't find anything about that. Let me check the Canton Citizen from that month. It was November 17th, 2013. Drag racing. Legally Blonde. I'm not seeing anything that would indicate to me what this is about. But this is a big hint. So Proctor says it's November 17th, 2013. All right. I gotta break this 1 second. New. The date of Michael Proctor's infamous "It's kill an N word in Canton Day" message was November 17th, 2013. Proctor made the statement made that statement in response to a message from someone named Hammer, and the text of the message is not revealed. And the text of that message is not revealed. However, someone named Leahy asks, "Can we confirm that this actually happened?" To which former Canton cop Sean Good replied, "Negative. Domestic between two blacks." It is unclear what prompted Proctor to Canton and begin murdering black people on that day. I mean, yeah, I don't really know what to tell you. That's really shocking and disgusting. I'm disturbed. I'm very offended. This whole thing is making me mad, and I just wanted a chicken sandwich. You're all so wonderful to keep my spirits high. This really makes me mad. God bless all of you. What page are we on? We're only on page 13. Oh. All right, let's continue. Now we're moving to May 22nd, 2014, where Leahy says, "and the smell." And then Proctor says, "well," and then N-word, "smell regardless." That's horrifying. And then Cookie says, "probably smells like a hockey glove." And then Proctor says, "Leahy, didn't you bone a B-word slur from Nobles?" Oh my God. Oh my God. Oh my goodness. Oh, it gets worse. It gets worse. Well, Proctorgate has continued to get worse, and the new messages, just a small batch of the 200,000 messages expected to eventually be released, are as horrifying as humanly possible. In these messages, Proctor and his friends use slurs about black people and say they smell. Then Proctor mocks his friend for sleeping with a from nobles. What is wrong with these people? Seriously. What is wrong with them? The most depraved. And these people, some of them had access to guns and badges. The slow drip of Proctorgate has infected more than just Norfolk County. It's permeating, ladies and gentlemen. It is permeating. And frankly, I'm offended. It's just so wrong. Just makes my soul sad. How do you even analyze stuff like that? It's just depraved. It's not stuff that should be around. It's hurtful. You can try to insulate it with as much levity as you can. But there's nothing that excuses some of this language. It's disgusting. I'm starting to realize this, and this is just a few of the examples. There's 200,000 of these messages. Proctor then sends a message that says, the first call that kid will make when a fellow N-word broke into his house or car is to the cops. Then Fargo says, river runs through it, still my favorite. Then Trendy says, oh boy, good luck. And then Proctor says, hola boys. Hammer, those blueberry donuts have been around since we were cubs. Blueberry cake donuts. They are awesome. Why do they keep calling each other cubs? Were they Cub Scouts? I'm so confused. Cubs is a very specific form of language to use. I know Proctor called himself Bear, but why does he refer to them as Cubs? Little League? Yeah, I suppose. I'm just hoping it's not like the other meaning. And then Proctor, out of nowhere, says, Pendy, I haven't shot anyone, but I did pull an N-word over today for tossing a cigarette out the window. Oh, we got it. We got the date. We got the date. Somebody tell Marbury v. Madison. All right. The Proctorgate revelations continue. Someone, the date that Michael Proctor pulled over a black man because he was June 10th, 2014. That should be enough to potentially find Proctor's victim. And then I'll tag Marbury v. I don't know how to spell Marbury. Oh, there it is. Source, page 16 of 36. This feels like when we used to go through the Epstein files. It's very important, though, that that man who got pulled over on that day be found. And it happened before the incident happened before 4:35 p.m. Eastern Time. So probably, he was probably on shift from 8 to 4. So it probably happened between 8 a.m. and 4 p.m. on June 10th, 2014. We can find that man. We can help him get justice. Alright, so then 6 days later, Fargo says, so if Bear is out, we need another. Possibly 2 more if Leak flakes out for Miss Silly. Good says, I could ask my brother-in-law if you guys approve. And then Proctor says back, so it's June 16th. I'm going to guess the U.S. played Ghana. Yep, I knew it. I knew it. I called it. I was right. Huh. Alright. It's unclear what Bear was out of. It is now confirmed. Michael Proctor was indeed talking about enslaving the entire country of Ghana, whom Proctor referred to as because the U.S. men's national team beat Ghana in soccer on June 16th, 2014. I knew it. I knew it. I predicted it. He literally, I didn't have the date. When we got these first, they were just quoted in a motion. So we didn't have the date. Now we know. Now we know. Michael Proctor wanted to enslave the entire country of Ghana because the U.S. beat them in soccer. That's the headline. Outrageous. During the World Cup. That's disgusting. Then Sean Good said, computer share? Wait a minute. Wasn't that in the Epstein files? Wait a minute. Wait a minute. Wait a minute. Wait a minute. Oh my God! Oh!
Conversation. This has to stop. I cannot take the deluge. Why was Jeffrey Epstein sending packages to Canton, Massachusetts companies as early as 2001? How deep does this all go? Earlier, I reported Jeffrey Epstein using a company called Computershare Investor Services, Computershare, Inc. in Canton, Massachusetts, as the paying agent for an offering of stock related to a company called Dynagas LNH Partner LP that is still operating. Sources to Epstein's stock offering being tied to Canton. Sources to Epstein sending checks to this Canton firm. Minutes before that.
Oh my God, it's the same company. What the hell? What the hell? What the hell? What is going on right now? Oh my God, I knew I had heard of that company before. I have a very good memory. Oh my God. I just wanted a chicken sandwich. Oh my God. Yeah, I do need some lunch. I gotta get through this, though. Welcome, Ronnie. Thank you so much for being here. I can't believe this has just happened. I must write this up. I can't believe it. 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 Sean Good on August 6, 2014 said Computershare has a ton of telemarketers that work midnight shifts and most of them are non-white, so now they have a fit home. And then Proctor says back, oh great, now the N-words have a straight pipeline to Canton. And then Larry Kennedy said they deserve access to good job too, guys. And then Proctor says Bear is headed to Brookfield, being reassigned. They're going to tip the S out of some cows. That's it. Proctorgate and Jeffrey Epstein have collided, and the implications could be stunning. What date was this text? In an August 6, 2014 text message, former Canton cop, Sean Good, messaged Michael Proctor about a company called Computer Share operating in Canton with telemarketers working midnight shifts. This company was directly tied. Telemarketers to Jeffrey Epstein. In I don't know what to say. I'm so baffled. I can't believe what's happening right now. That's such a random thing for Sean Good to say. I knew it. I fucking knew it. These motherfuckers. They think they're smart. These motherfuckers. They're not smart. Oh! I'm stunned into silence. Oh my god. I told you this was going to get dark. And this is all you need to know how to read these documents. Because there's stuff that hides in plain sight. I can't. My brain, my mind, I'm really hurt. I know where this is going to go. I told you all where this was going. I saw it coming. I saw it coming. I knew it. I knew it. It's not the smoking gun, but we're on the path. We are on the damn path. I knew it. I knew it. There's no way Sean Good is just randomly referencing this company that was tied to Jeffrey Epstein. Got him. My ass, Sean Good just randomly talked about that in their midnight shift telemarketers. Fucking stock paying agents. I knew it. I heard that name, Computer Share, and I remembered. Rosemary never would have known about that. How would it? You would have had to have reported on Computer Share being in the Epstein files. I'm gonna get these people. Juridically, I'm gonna get them. I knew it. I knew it. I knew it. I knew it with my heart and soul. Getting all mad. I haven't eaten today. I clearly take on too many things, and I can't find my towel lighter, and now I'm mad. Did I throw it? Did I become, like, ensorcelled? That's a good word. Alright. There it is. I found it. There's something off about the whole thing. Now, it is a pretty large clearinghouse for purchasing stocks. But Epstein patroned a lot of businesses. Other people patroned. That's not the real insight here. The insight is that Good was talking about a business that Epstein used at the time, within, 6 months, 12 months of that date. Epstein used it in 2013 to buy like a strange series of stock options involving like a liquefied natural gas company. Yeah. There's something off. It's all off. Everything about it's off. Michael Morrissey, Quincy, the Marina, NJA, Wealth Management, State Street, just Epstein. Everything about it's off. The Police Explorers program, the restaurants, Epstein going to Stoughton, the Tiffany Overstreet thing in 2013 and 2014. It's just, I'm telling you, I'm right. I can't prove it yet, but I will. Even if I don't end up proving it, I've already told the government. I'm right about this. This isn't the smoking gun, but I'm telling you, this is not a web of coincidences. I'm not a coincidence theorist. I don't believe in that, all right? Coincidence theory is a little bit of a esoteric, strange world I've never really understood. No. There are too many layers of connections. There are too many simultaneous developments, and there's just too much overlap. And it all points to one thing. Jeffrey Epstein's network only existed because he had people everywhere. The human trafficking was coming from inside the house. Kimmy loving stuff. Listen. I don't mind if you want to project a little bit. I understand, you might have things going on. But if you ever weaponize mental illness again to distract from talking about what's going on in the Proctorgate files, not only will I name you and remove you permanently from this honorable house, which I've already done, but then I'll call you out for your egregious and offensive misconduct, which violates the spirit of compassionate discourse and undermines everything that I think this channel should be about. So anyway, have a nice day. How rude. Weaponizing mental illness to try to cover for Michael Proctor. I've never seen anything like it. Holy towel ground. All right, let's go to the next page. I would like to order my chicken sandwich, so let's get through this. And then I want to hang out with Towel Girlfriend. All right. So now when do we move to? Now we move to October of 2014, October 14th. Fargo says, not forgotten by me. Then Larry Kennedy says, Bear, so he's addressing Proctor, I was thinking that last week. Tons of great tunes. Proctor says, I would love to see them live. Proctor then out of nowhere says, 2 park rangers stabbed in Boston Common, and then Proctor says, has to be the work of an N-word. And then Proctor says, which is utter BS that these N-word animals resort to that. And then the same day, Proctor says, I hope he isn't. Seems out of context. And then Proctor says, on October 1st, 2018, so jumping forward 4 years now, these are completely random, I'd rather a C word, C-O-O blank, I'd just shoot, says Proctor, the N-word, or scare him off by telling him he has to work. Okay, that's, then Cookie, not Sean Good, Cookie says, ha 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 ha. Okay. All right, now July 9th, 2019. Proctor says, Kenner, these N-words are holding signs for you at the All-Star game. Oh, okay. And then Proctor says, on July 9th, 2019, you okay? And then Foley says, something nomics, financial system run by N-words, by which a prosperous nation is converted to a cesspool of poverty and misery. I'm going to guess he got that from Urban Dictionary. Hold on. Oh, they don't... Urban Dictionary, I don't even think that's indexed by Google. Nope, I can't find that definition anywhere. Okay, I don't know what to make of that. I can't really see, like, I can't really tell, like, what that word is. Frankly, I don't want to know. Oh. I figured out what it is. I can see what it is. It's like a very bad slur, obviously, and they're using it to... It's Foley sending it to the group to mock, to insult black people. And then Larry Kennedy says back, teen apers? Oh, I knew it was a website. And then Foley says, Mike, this site is your internet haven for new terms. Larry Kennedy says, it's incredible. And then they were all using Twitter, and they linked to an account called DC Drano. So where did they get this definition from? Oh, I see what it is. Well, I want to figure out which site they were using. We're back. Hello. I want to see where they got this. I want to know what website they were using. And it's just such specific wording. It has to lead me back to that. There's no results on Google for it at all. Nothing. That sounds delicious, Talmud Bunny. This is horrifying to read through. And let me see if this tweet's still up. Hold on. Let me see if I can... I mean, you can see what the tweet says, but let's see. Maybe one of them interacted with it. Twitter.com, DC Drano, status 1273364 1225209528833. Is this post still up? Yep. Yes, it is. It is a video of... I'm not going to show you it. It's a video of 3 guys, they are black guys, beating a white cop in a McDonald's. And the white cop gets pinned to the ground, and the black guys beat on him. Then one black guy chokes the cop from behind. This was posted on June 17, 2020, yeah. It went viral, so it's tough to tell. Yeah, that's bad. Wow. So that tweet is very disturbing. They're sharing it like to entice the cops to be afraid of black people. There's cops in this group with them. Southeast Alley, I agree. That sounds delicious. I don't know what I'm going to get. I think I'm going to get a chicken sandwich for lunch. I need to think about lunch because reading this is horrifying. We're almost done, and then I'm done for the day. And this has been a lot. I was not expecting this. This has been horrifying. Proctorgate has expanded in all of the worst ways. Fargo says, I wouldn't police the black neighborhoods. Honestly, let them do it themselves. Okay. And then this seems to be a screenshot. Fargo sends what looks like this guy was a sicko terrorizing his wife and kids. What? So he sends Fargo sends a screenshot. I can't tell what the screenshot is. It's an attachment. And he says, this guy was a sicko terrorizing his wife and kids. And it was sent on June 17th, 2020. Oh, hi, Tiffany Bob. God bless you. How are you doing? I hope you and your mom are okay. Welcome, Redacted. Doing Redacted. All right. Kevin Foley says, oh, wait a minute. We got the guy's name. CK. Fargo's. Wait a minute. Is that the same day? 6/17/2026? So Fargo's real name is CK. Who in Canton or who around Michael Proctor has the initial CK? Very interesting. New via new Proctorgate messages. One of the people Michael Proctor was talking to on his abhorrent and bigoted message chains was nicknamed Fargo. This person's initials are CK, according to another message in the chain from Proctor's friend Kevin Foley. I think that was the one. Foley was the one who hosted the fundraiser for John O'Keefe's niece and nephew in 2014. These messages also show Foley, who hosted a fundraiser for John O'Keefe's orphaned niece and nephew in 2014, was talking to Proctor in 2020. Alongside Kevin Albert. Both Kevin Albert and Proctor were involved in the investigation of John's death in 2022. Yikes. All right. And then Kevin Foley says, let them kill each other, referring to the people in Chicago. Okay, that was now on 6/19. Oh, they're talking about Juneteenth. Kevin Foley says, when the last slaves were freed. Then Kevin Foley says, they make it out to sound like there were millions of slaves. Only 5% of whites had slaves in the 1800s. Okay. New. Here is how Michael Proctor and friends were talking about Juneteenth in 2020. The Proctorgate files expand by the day. This is a lot. Oh. I got gifted a channel membership to someone. That's nice. I'll have to look into that. Source, page 26 of 36. Maybe that's why the Michael Proctor support party happened the other night on that date. All right. Let's continue. They're doing this in the O'Bannon trial, says Larry Kennedy. This is June 11th, 2014. Some former player from Alabama is doing the same thing, complaining that he took cream puff classes. My only question is, are the players making these accusations not accountable? And then Kevin Foley says back to that, I hate N-words. What? And then Leahy says, even Omar Little? What? What's the O'Bannon trial? Oh, this was an early case leading to NIL. Just wow. Now we're going to October 14th, 2014. Good says, I bet they will be armed by year's end. Good says, one is in critical condition. And then Trendy says, Bear, go get the N-word and string him up. What kind of a-hole? Stabbed 2 park rangers. They just want to protect the trees. And then Good says, why are unarmed park rangers confronting large black homeless men? Okay. Fargo then says, on October 27th, 2014, ESPN magazine interview with Brian May. Queen decided that it needed a simple and rhythmic tune that could connect with the audience. The morning after the show, May woke up with a stomp, stomp, clap beat rolling around in his head. To accompany that big rhythm, he sat down and wrote depressing lyrics that described the futility of man. The lyrics began with a young man dreaming of a better life. In the second stanza, the boy is now a young man battling to reach 3 stages of soul, where he says most people don't reach the 3rd stage. The chorus is not a rally call. It is a Czech lullaby, which a parent promises a child, we will rock you. Great article by Seth Wickersham tracking down the meaning of the most popular stadium anthems. The song was recorded in an empty church because Queen loved the acoustics. Larry Kennedy says that's crazy, a lullaby. And then the urban slangs. Oh, he's back to quoting from this site. At the urban slangs. So what the hell was at the urban slangs? No, not the urban slang. The urban slangs. Can't find this anywhere. All right, what's going on in chat? What's going on? Share Bear, is everything okay? Yeah, Share Bear, I hope you're doing all right, but, you know, we're talking about the, hi, Kyle Sharkey, Share Bear, we're talking about the Proctor files, so, yeah, chat reset indeed. All right. God help us all. Hashtag chat reset. Talmon Bunny would like to see your emojis. So, feel free to post some emojis. We do like emojis. It's almost lunchtime for me. Reading through this stuff literally will alienate you. It makes you just loathe humanity. Thank you, Tiffany Bob. That was a great emoji. Connor Keefe? How old is Connor Keefe, Kyle Sharkey? Is he from Canton? We need to know where he's from. We need to see his CV. We'll have to keep looking. Well, we're here for you, Cher Barrett, but I hope you're okay. All right. Now we are... So it's Foley quoting at the urban slangs, which I can't find, a rocket N-word. And Foley says a N-word attached to a rocket who lies around stealing stuff like cars, basketballs, fried chicken, and people's legs. That doesn't even make sense. I mean, I guess it kind of makes me feel good that the racists are dumb, but that doesn't even make sense. All right, now Good says, this is on November 24th, 2014. And he says, because if they charge him, he will be found not guilty because there is no evidence to convict him. And I feel they will riot worse if they get dragged through a lengthy court process. So this was probably about the officer who was not charged in that case in 2014. And then Foley says, N-words will riot no matter what the outcome is. And then Proctor says, whatever the course of action is, these N-words will riot. And then, I don't know what the hell this is. I can't make this out at all. I'm going to have to reverse the gradient on this. Or change how it displays. Because I can't tell what this is at all. It's like reading one of those images you'd look at on the wall where the image would kind of come out of the background. It says oh, there's no chance I'm going to be able to figure out what this is. No chance. This is a good insight into where this came from, though. Private VAR MCBI or mobile containers shared app group. So it's a full zip private var mobile containers. What? What? So this, I can't tell who's sending that. This is Fargo. He says, even 3-year-old. Oh! Oh! That's terrible. Oh. Oh. Oh, Proctorgate is just getting worse by the day. I don't even know what to say at this point. Proctorgate has reached unfathomable levels. One of Proctor's friends, named Fargo, said, quote, even 3-year-old, I'm not saying that. are terrible humans. I mean, they're just little babies. They're little babies. The levels of depravity we've reached with Proctorgate, no bounds. It's just the worst things you can possibly imagine all the time, and this is the first batch of what could be thousands. What does this one say? What? I can't make this one out at all. What? Okay, I can't make that out at all. Sorry. And then this one says, Larry Kennedy said, shoot a... Oh, God. Oh. Oh. And then this one says, no, I can't make that one out. I can't make that one out. I can't make that one out, even at 400%. It's from Leahy. So the path is zip private var mobile containers shared app group. This is from Cookie, and it's a meme. The top part of it says, look, son, and then there's a bunch of pictures, and then I can't read what's under it. That's very odd. And then there's one from Cookie that says, the animals are smashing the police station in Ferguson again. Off-duty cop killed 18-year-old black kid that opened fire on police during chase. October 9th, 2018. Ferguson. Not going to be able to track that one down. Some of this is like reading code. On February 9th, 2015, Good says they effed up by burning that pilot. What happened February 9th, 2015? On February 3rd, the extremist group ISIS released a graphic video captured showing Royal Jordanian Air Force Lieutenant Mutaf al-Kabaz being burned alive. Why was Sean Good talking about ISIS releasing a video of the Royal Jordanian Air Force Lieutenant Mutaf al-Kasibayeth being burned alive? Maybe it was in the news. And then to that, Fargo says, let the sand N-words kill each other. Then Larry Kennedy says, yep, they can push around the West, but Jordan proved they won't take their shit. Well, yeah, Nope. And then Good says, now we need Saudi Arabia and Egypt to get involved. And then, is this the same day? Nope. Okay. Why did Good want Saudi Arabia and Egypt to get involved? Why was he following the war with ISIS? Ugh. Side note, I thought the chant was hilarious. March 9th, 2015 from Fargo. Larry Kennedy said, "Me too. College kids being college kids. Easily could have been us any weekend we're together." And then Fargo says, "Fight, fight, an N-word and a white. White don't win. We all jump in." And then Fargo says, "We all said it as kids." And then Foley says, "Something N-word day." And then Fargo says, "That'd be a great holiday." And then Hammer must react. And then Trendy says, "I might walk up later on." All right. I'm officially perturbed. That's been a very, very disturbing. Oh, Southeast Sally, welcome to the channel. How you doing? Larry, I agree with you. Welcome to the channel as well. I haven't been as close to chat as I'd like to normally because I was reading some terrible things, but God bless you all for being here today. That was no Crazy Brazilian, so I did get my address to Attorney Melanie Little, but I have not gotten it, but as soon as I do, you will know. All right, I'm hungry. I'm getting out of here. We'll do our traditional outro. That was a wild day. We went from the Colin Albert hearing to the Army regulations in the CFR to more Proctorgate. Proctorgate has exploded again, and this time it's somehow worse. All right, Peep, where are you? You got to say hi to your friend Francine. This is the channel mascot. His name's Peep. He's a stuffed bunny. If you've ever been around on these streams, you know Peep shows up at the end of the stream. He's a stuffed bunny. So this is Peep. If you've never met Peep before, he is the channel mascot. He helps us decompress, after intense things. Oh, hold on. Having some frame drops. Give me a second. We're back. Hello. So this is Peep, all right? Peep is the channel mascot. I'm going to ask Towel Girlfriend to make a plushie of him. He hangs out with me at the end of streams. His friend Francine really loves him. So, but yeah, that was quite a stream. Thank you all for watching. I intended to just cover the Colin Albert hearing, and then Proctorgate exploded. Expect that to be everywhere. We have not actually seen the messages until now, and they're horrifying. But yeah, this is Peep Bunny. He's the channel mascot. We also like to do Tip a Canoe and Tyler 2 at the end of the stream. So if you enjoyed today's coverage, if you want to feed Towel, thank you to every one of you who did super chats. Thank you to Southeast Sally for becoming a member. God bless you. Enjoy your towel emojis. We have some wonderful ones. Thank you, It's Me, Andrea, for being here. Thank you, Towel Mom Bunny and Kofi for being here. And Mercury Star and Marsha, God bless you, my friend. Apparently Melanie Little has been giving Towel compliments. I return those compliments. Melanie Little's been doing some excellent work. 3 Clerk Monty, it's so good to see you. Wonder if CK is a secret digital evidence lab director. Interesting. 3 Clerk Monty will have to continue discussions. Oh, we need a new Discord link. Hold on. I can do that. Hold on. I set the Discord links to never expire, but I think sometimes they just expire. Even though I set them not to, they just expire. There's nothing I can do. But I can make you a new one right now. So let me do that. Give me 1 second. Nope. Aiden Carney has filed his notice of his motion to dismiss in the Karen Reed case. Brian Tully has filed his notice of motion to quash his subpoena. All right. I am going to make the Discord link update, so give me 1 second. never, and no limit, and here we go, and all right, so here is the new Discord link. I'm going to put it in the stream settings because then it will show up every stream going forward. That's how I like to do it. We have a new invite link. I'm going to drop it in the chat now. There it is, Towel Mom Bunny. And now I also have to do one more thing. I have to go to Nightbot because Nightbot's his own thing. He's like he's a mind of his own, ladies and gentlemen. As some of you know, a lot of people have love-hate relationships with Nightbot. Now, I really like him. You know, he does good work, but you got to keep him up to date. So now, Towel Mom Bunny, thank you very much for letting me know. If you type Discord, the new link should populate via Nightbot. Let's take a look. Good job. Excellent job. Share Bear, is everything okay? You know, a lot of the comments you've been making haven't really been related to... I'm here. I'm listening. Give me a second. Frame drop. I'm back. Hello. I'm a towel. Francine, let me get your friend Peep. He's back. All right. So, with that said, thank you all for supporting Towel News. That was a lot. I was not prepared to do Proctor messages. You kind of got to get in the right mindset. That was sprung on me. I was able to do it. So, yeah. In any event, this is Towel News, youtube.com/@GrantSmithEllis. Thank you all so much for supporting Towel News. If you'd like to support today, thank you again to everyone who's supported the mission here, which is to educate, inform, and entertain, such as to engender cogent public discourse and ward off the usurpation of our representative or otherwise forms of government worldwide. You can get me a coffee, you can get me a lunch. There's a Cash App, $GrantSmithEllis. There's a Venmo at GrantE1. There's a PayPal, paypal.me/GrantEllis. You can also like, subscribe. Both of those things are free. You can become a Towel member on the channel, etc. Thank you all very much for supporting independent journalism. And even though we didn't know we were going to read Proctorgate messages, thank you very much for sticking with me as we did that. Pick a handle. It's so good to see you. And then this is Pete Bunny Towel, as I was mentioning. At the end of every stream, we like to end by doing the presidents in order. We call it Tippecanoe and Tyler 2 in honor of my friend Triple Bob to test my mental acuity. All right. So, let us begin. President Washington, President Adams, President Jefferson, President Madison, President Monroe, President Adams Jr., President Jackson, President Van Buren, skip 9, 10, 11, 12, 13 is Millard Fillmore, now Tippecanoe and Tyler 2. So that's going to be Polk, Taylor, Pierce, Buchanan, Lincoln, Johnson, Grant, Rutherford B. Hayes, Garfield, Chester A. Arthur, Cleveland, Harrison, Cleveland, McKinley, Teddy Roosevelt, William Howard Taft, Woodrow Wilson, Harding, Coolidge, Hoover, FDR, Truman, Eisenhower, Kennedy, Johnson, Nixon, Ford, Carter, Reagan, Bush 1, Clinton, Bush 2, Obama, Trump, Biden, Trump. How you like them apples? My name is Grant Smith Ellis, as I mentioned. That was Tippecanoe and Tyler 2. Thank you very much for being with me on Towel News. As you know, I like to end the streams the same way every day after Tippecanoe and Tyler 2, which is to say, if you learned something today, if you want to pay it forward, if you enjoyed, if you found camaraderie here, do consider, ladies and gentlemen, making a donation today or to pay it forward via a small act of service and kindness. Consider making a donation to our veterans or service members or our homeless veterans or their family members. There should not be one veteran homeless in the United States of America against their will, and we can help them today, ladies and gentlemen. Do consider such a donation. You may also consider a donation to animal shelters run by veterans or that help our service members or veterans. Great way to help our vets, great way to help our furry friends, great way to help our service members. If you can't find such a charity, you may consider a donation to an animal shelter in general. Pete Bunny Towel will be very proud of you. If you're in the UK, please consider a donation to The Big Issue. Great way to help populations experiencing homelessness in the UK. If, in turn, however, you would like to consider something other than a donation, you may consider something as simple as smiling at someone on the street, reaching out to a friend or family member you haven't heard from in a while, or yes, even giving away 200 tomato plants like Francis Futrell did one time and having them designated honorary towels during the outro forevermore. In that way, ladies and gentlemen, may we pray the current realpolitik continues to shift from one centered on preserving, expanding, and demonstrating our power to instead one centered on preserving, expanding, and demonstrating our capacity to engage in small acts of service and kindness rooted in unconditional love, thus living up to our tau eudaimonia or summum bonum, our greatest good in the ancient Greek or Latin respectively, and in turn bringing about a new digital epic defined by Aquarius the water bearer standing tall and carrying a towel. My voice is tired. I'm going to sign off now. We're not going to do our traditional outro because I don't know what the hell that stream was after that chaos of the Proctorgate files. Aaron, Pick a Handle, Francine, Tiffany Bob, Towel Girlfriend, all of you. You've been wonderful. God bless you. Thanks for being with me today. Thank you for supporting Towel News. Thank you for being you. God bless each and every one of you. God protect the United States. May God protect us all. That was a lot. I haven't eaten in like 2 days, so I'm going to go order a chicken sandwich now. I'm going to hang out with Towel Girlfriend. Thank you again for supporting Towel News, and thank you again for being with me today. Signing off for now. My name's Grant Smith Ellis. It's 1:45 p.m. Eastern in Boston on Wednesday or Tuesday. Is it Tuesday, June 23rd, 2026? The England game in the World Cup against, I believe, is it Ghana? Is it against Ghana? Is in 2 hours and 15 minutes. I guess we know who Michael Proctor's friends will be rooting against. It is 7:45 p.m. in South Africa. It's 8:45 p.m. in Tel Aviv, Israel, and it's 9:15 p.m. in Tehran, Iran. Larisha, God bless you. Thank you for being with us, and thank you again to all of you. I need to just go eat now. I'm becoming delirious. My name is Grant Smith Ellis. From me and Pete Bunny, we love you all dearly. God bless. Be well. Bye, silent dogs.